Angelica is done.
Good morning. I'm just testing my sound. Could someone say good morning?
Good morning. How are you?
I'm perfect. Thank you. very
Morning. Right.
Madam Hearing Examiner.
Yes.
Hey, good morning. My name is Philip Simpson. I will be cross-examined later this morning. I can exit right now to YouTube or stick around for initial stuff while whatever you prefer.
Really either way, I think as long as once we get started, anyone who's not needed with respect to the examination of witnesses or the witness themselves should switch to YouTube just to reduce the bandwidth on the streaming.
Okay,
So,
I'll stick around for a few minutes just in case there's a question about scheduling or something.
I'm going to go with the time on my laptop. I guess that's PRC time, even though I don't think that's the world's time according to my cell phone anyway. But according to my laptop, it's 8:57. So we have a couple more minutes just to make sure everyone's here. And then we'll get started.
Madam Examiner, this is Lisa LaRock again. My camera's not working. I would need to reboot my system. Do I have time to do that? It will take like.
Yeah, go ahead.
Okay,
that's
great.
fine. I mean, you'll be the first witness, but we'll be taking care of some housekeeping matters.
Okay, thank
anyway.
you.
So I'll watch for you in the waiting room and readmit you. right, Ms. Gonzalez, are we ready?
Yes, ma'am.
All right. Good morning, everyone. We're here this morning in the matter of 22-00093, El Paso Electric's application for its renewable energy plan. We're on the record now. So I just want to start by making sure we're all clear on what witnesses we will be hearing and the order of the witnesses. Before we do that, look, why doesn't everyone who is here, either counsel or pro se parties, enter their appearance for the record?
I can start. I'm Mary Lee Souls. I'm a pro se party in this case.
Thank you, Ms. Souls.
Good
This is-
morning, Madam.
Go ahead.
Good morning, Madam Hearing Examiner Carrie Olson from Montgomery and Andrews, and with me is Jeff Wexler on behalf of applicant El Paso Electric Company.
Good morning, Ms. Olson. Mr. Downs, go ahead. Oh, you're on mute, Mr. Downs.
I'm sorry. I'm Alan Downs. I'm a pro se intervener. Madam Hearing Examiner, the Wi-Fi is down at my home, so I'm in a restaurant. I'm afraid there may be some background noise. I'll keep my microphone off unless I need to speak.
Thank you, Mr. Downs.
Madam Hearing Examiner, this is Anastasia Stevens on behalf of the City of Las Cruces. And with me today, I think, well, maybe she's not, our last witness, Lisa LaRocque, is probably still trying to get in. I don't see her on the little.
I just admitted her from the waiting room.
Thank you.
Mhm.
And I'm in a sort of noisy place too, and I'll try to mute myself as much as possible.
Great, thank you. Any other counsel or pro se parties?
Yeah, good morning, Madam Hearing Examiner. This is Kevin Gedko, representing the New Mexico Office of the Attorney General. Gideon Elliott and I will need to switch off at certain points today due to different meetings that we have and such. So I want to give you a heads up with respect to that. Thank you.
Thank you, Mr. Gedko.
Madam Hearing Examiner Keith Herman on behalf of Doña Ana County.
Good morning, Mr. Herman.
Good morning, Madam Hearing Examiner Gloria Regensburg for PRC staff.
Thank you, Ms. Regensburg.
And good morning, Madam Hearing Examiner. I am Bradford E. Borman, appearing on behalf of Utility Division staff.
Thank you. And I see that we do have some witnesses or parties present as well. If you want to go ahead and introduce yourselves. Ms. Pleasant, I guess you could start. Oh, you're on mute, actually. Oh, Ms. Pleasant, you're on mute. Okay, well, anyway, that was pretty garbled, but okay. We also have Ms. LaRocque, who I believe will be our first witness today. Is that correct?
Yes, hello, everyone. Hello, Madam Hearing Examiner. Yes, my name is Lisa LaRocque, and I'm from the city of Las Cruces.
Thank you. And I believe finally we have Mr. Simpson and Mr. Tepler, who are both witnesses later today.
Good morning, Madam Hearing Examiner. Yes, my name is Philip Simpson. I'll be testifying for Mary Lee Souls.
Okay, thank you.
Yes, and hi, good morning. My name is Mark Tupler. I'm representing PRC staff.
Thank you, Mr. Tepler. So just to reduce the bandwidth and to hopefully keep the quality as good as possible, I would ask that any witnesses who may be testifying later, please sign out of the Zoom meeting and watch on YouTube until it's time for you to testify. Similarly, if we do start to have any issues with streaming, I will suggest that individuals who are not speaking could turn off their video. But right now it looks pretty good. So hopefully everything will go smoothly today. Now, my understanding, so Ms. Pleasant, you're with EPE, I understand, because I could not understand anything that you said earlier. You're with El Paso Electric?
Madam Hearing Examiner, I think she's having audio issues, but Linda Pleasant is the regulatory case manager for El Paso Electric and is on the ground in El Paso in case we need anything from the company.
Okay. All right, thank you. So my notes indicate that we'll be starting with the witnesses from the city of Las Cruces today. We've completed testimony from EPE's witnesses and the Attorney General's witnesses. Is that correct? Yeah. Yeah.
Madam Hearing Examiner, Mr. Provencio and Mr. Reyes testified on the second day of the hearing. So it's just Ms. LaRock, the third city witness who's up for today.
Okay, thank you. And that'll be followed by Ms. Souls' witnesses. And can you just remind us of who your witnesses are going to be today, Ms. Souls?
Yes, ma'am. So I will testify first, and then my witness Corey Aspel, and then my witness Philip Simpson.
Mr. Downs, do you expect to, well, you don't have any witnesses, correct?
Correct. I have no witnesses.
Okay. And Doña County, Mr. Herman, you have no witnesses?
No, we have no witnesses to put on in this case. Thank you.
And then we will have two witnesses from the utility division. Is that right, Ms. Regensburg?
This is Mr. Borman. That is correct. We have Mr. Tupler and then Mr. Otara.
Okay, thank you very much. I think one of the other matters that we have to address is adjusting the briefing schedule. I think obviously given the change in or the addition of this day, we want to move the due dates for the briefing out a little, particularly so we have an opportunity to have a full transcript before briefs are submitted, obviously. So Ms. Gonzalez, what would you anticipate as far as assuming that we have a relatively full day today? What would be your expectation as far as a transcript? And if we are going to need an expedited transcript, obviously we need to address the issue of the additional payment for that as well.
I have been told that this will be an expedited transcript, so I will have it no later than Monday. I can have it as early as tomorrow evening, probably, if I needed to.
So if we move currently we have initial briefs due on February 23rd with rebuttal briefs on March 3rd. I guess what I'm wondering is moving each of those dates out a week. Is that sufficient? Anyone have any thoughts on that?
Madam Hearing Examiner, this is Anastasia Stevens, and as I think I told you at the end of the last hearing, we've had some email discussions about whether it would make sense to move it out to that week, or given that that's a couple of days before the next hearing,
Right.
move it beyond, because I don't think that you or any of the rest of us will really spend a lot of time that week reading the briefs. So I think our collective preference is to move the briefing schedule to a point after the briefs on the hearing on the 7th and the 8th. And what we don't have is an agreed upon proposed date. So I'll just turn off again. Sorry about the background noise. I'll turn off my sound and let anybody else weigh in about dates after the 8th, if that's amenable to you.
Yeah, I don't really have a problem with that. I mean, in which case I'm looking, I think, maybe at March 14th or 15th for the initial briefs then.
Personally, I can say that would be very generous and very much appreciated. I assume that there's a consensus on that point.
Is there any other thoughts on that?
Madam Hearing Examiner, the company is open to whatever briefing schedule works for you. Their only concern is getting the final order within the 6 month
Right.
deadline, and so I don't want to put you in a pinch. And one thing that the parties
Right.
had discussed, if it would be helpful to you, is the possibility of submitting a proposed recommended decision on non-contested issues, and then parties could brief their positions on the contested issues. I don't know if that would be helpful to you, or if what your preference is on that, but something we'd certainly be willing to work on.
No, I think that would be really helpful. Absolutely. And I mean, I'm looking at, we have those other hearing dates on March 7th and 8th. So that's what I was kind of looking at early the following week. I mean, I'm wondering about March then. March 14th for the proposed recommended decision on the uncontested issues. And the initial briefs, would that make sense? And then let's look at having the response briefs on the 20th.
Madam Hearing Examiner, I missed that first date. Would you say it again, please?
March 14th.
Very well, thank you.
So the proposed recommended decision on uncontested issues and briefing on obviously contested issues, and then response briefs would be due on the 20th. All right. So I should think really Monday for the transcript should be fine, unless anyone thinks they want it tomorrow.
I wouldn't
Okay.
do anything with it tomorrow.
Over the weekend. All right, so we will let Ms. Gonzalez have until Monday, close of business Monday for the transcript, the expedited transcript.
Very good, thank you.
Okay. All right. And just, I would ask and you know, I might go over this a little bit more at the end of the hearing, but for purposes of organization on the briefing, it would be very helpful to me if the requirements of the rule could be followed as an organizational tool for the briefing. You know, starting with 572, like point 12, reasonable cost threshold. What do we have to say on that?
I'm sorry, reasonable.
Oh, well, point 12, I mean, I'm just looking at the rule. So 572.12 addresses reasonable cost threshold. I just would like, and then, you know, point 13 is resource selection. Point 14 is the plan with subsection B, kind of laying out all of the things that need to be in the plan. I know with the recommended decision I'm writing right now, I feel like I'm just like jumping all over the place to find that each element of the regulation is satisfied through the application and testimony in that case. So I thought it might be helpful to look at some organization of briefing, kind of tracking the way the rule is laid out. 572, part 5, you know, 17.9.572, the renewable energy rule. So anyway, but I'll address that a little bit more at the end of the day. So I think at this point, then we are ready. I'll get an order out on those new dates for briefing in the proposed RD, which I appreciate the parties proposing that, and I think that will be helpful in facilitating this matter. And I think at this point, yes.
Oh, I just had one other quick procedural question for you before we get started. EPE submitted that response to the bench request after the close of the first 2 days of hearing, and I just wanted to find out from you whether you want that to go in the record as possibly another commission exhibit. We haven't marked it yet or anything because I wasn't sure how that would happen.
Yeah, I think we should do that. I think that would then be
I think it's 4.
Commission Exhibit 4. Yeah.
Okay. I'll have our paralegal mark that and upload it. Does
Okay.
that Dropbox link that you sent to upload exhibits, is that still alive?
I believe so. Yeah.
Okay.
If there's any issue, let me know, and I'll send it out again, but it should still be live.
Okay, thank you.
Mhm. Okay. So Ms. Stevens, you had some additional exhibits as well. And then there was a replacement on Exhibit 10.
I did, Madam.
Good morning.
Good morning. Good morning. I did, and pursuant to some email messages that we exchanged, and thank you, Ms. Gonzalez, for the transcript. It really helped because I don't know what. So we left off at the end of the first day with CLC Exhibit 11 and 12, which were the Buena Vista 1 purchase power agreement that was approved in case number 19-00349 UT, and CLC Exhibit number 12, the proposed amendment to the Buena Vista 1 PPA, which is now currently pending in case number 19-00099 UT and 19-00038 UT. Your cases also. So, and I think we left off at the point that Ms. Olson had agreed that they should go, that once we had both pieces in, she didn't have an objection to that. And you said that you would defer it till the next day. And of course, the next day came and I failed to get it into the record. So I guess I would ask again, or seek a ruling or raise the motion again to admit CLC Exhibits 11 and 12.
Is there any objection to CLC 11 and 12. But I believe the Buena Vista one PPA, you said 349, but I think that actually
Oh,
that
I'm sorry,
was
Jess.
originally 348.
Yes, 348. I'm sorry if I said
That's
349.
okay. So the exhibits 11 and 12, are there any objections?
No objection.
Exhibits CLC City of Las Cruces exhibits 11 and 12 can be admitted then.
And then I have several orders and stipulations from previous cases relating to EPE's renewable portfolio standard requirements, all of which were discussed with EPE's witnesses, primarily Mr. Novella. What I have, and these have been renumbered to maintain some level of sequence. What was previously referred to as CLC Exhibit 5 is now labeled CLC Exhibit 4, and that is the final order in case number, I'm sorry about the noise, 19-000349-UT, and that is definitely 349. That's the Newman 6 case. And again, whether you prefer to treat that as an exhibit or a request for administrative notice, I think the intent was to get the documents actually into the record. That's the first one.
Okay.
Do you want to do them all together or one by one?
Well, is there any objection to CLC Exhibit 4?
Madam Hearing Examiner, that if at some point, if the city could submit an amended exhibit list, that would be very helpful. If I understand correctly, this one is the final order from 19-00349 UT. I don't really see the relevance, but it's an order of the commission. I certainly think it can be cited to, relied upon. If we want it in the record, that sounds fine to me. So we have no objection.
I think Ms. Stevens did submit.
Mr. Wexler, there is an updated exhibit list as of whatever is yesterday, the day before when we uploaded.
Thank you.
Okay, go ahead. What's next? Ms. Stevens.
The next one is now labeled CLC Exhibit 9. It's from case number 19-00099 UT, which is the case in which Buena Vista 2 and Hecate 2 were approved. The package that is now in there as CLC Exhibit 9 is the order adopting certification of stipulation, which was dated December 12th of 2020, and the certification of stipulation, which was dated October 9th, 2020. The certification of stipulation has a copy of the stipulation attached to it. So it's technically two documents rolled into one, but three key pieces, all of which constitute the commission's order in that case.
Okay. Any objection to CLC Exhibit 9?
No objection.
Thank you. Exhibit 10.
Exhibit 10 is similar to Exhibit 9. This is case 21-00111-UT, EPE's last renewable energy case prior to this one. There is an order adopting certification of stipulation dated November 17th, 2021. And there's a certification of stipulation dated November 5th, 2021. The certification has the stipulation attached to it. And
any objection to Exhibit 10?
Objection.
Thank you. And then I think the last one we have here is Exhibit 13.
And this is a tentative one because I didn't know whether the company or other parties to the case number 19-00099 UT stipulation would like to have it. This is an amendment to the stipulation filed in accordance with the certification and final order on December 7th, 2020. And it has to do with the amount that came up in Mr. Rodriguez's testimony, I believe it was, on the $23,000 adjustment for the CRLEF rec payments back in, we're in ancient history now, in 2018. And that's just to tidy up the package. It's incorporated basically in the ordering provisions.
Well, obviously, as an order of the commission, it's certainly something we can take administrative notice of, and it may be easier to have it as part of the record if hopefully it's actually used and referred to. Any objection to CLC Exhibit 13?
No objection.
All right, so given that there's no objection, I will admit CLC Exhibits 4, 9, 10, 11, 12, and 13. And Ms. Gonzalez, do you still have access to the Dropbox for those exhibits?
I'm
Or
not sure about that.
I'll send it to you.
And Ms. Gonzalez, I want to make sure that you see that there are two Exhibit 10s in the Dropbox. It's the latter one that's also larger that I just moved to admit that has the final order, not just the stipulation. I don't know how to take things out of a Dropbox. I don't know whether I can take things out of the hearing examiner's drop. I don't think she would let me.
I'll do that.
Okay.
I'll take it out before I send you the link, Ms. Gonzalez. So hopefully there's no confusion
Thank you.
on that. Sure.
And it was allowing uploads this morning. Ms. Souls asked about.
Okay.
Madam Hearing Examiner,
Yes.
Staff would like to review the exhibits we filed yesterday, or we uploaded yesterday, if that's okay. So
Sure.
we reloaded staff exhibit 1 and 2, which were the same ones that were added back in January. And we added staff exhibit 3, which is the notice of Epe'S compliance filing, which contains the 5th revised, what is it? The notice, advice notice, right? And so I don't know how, would you take administrative notice of that? I know that we had discussed that on the 30th about allowing that to be presented.
I think that we can. I mean, certainly as a filing with the commission, we can take administrative. We should be able to take administrative notice of it, but are there any objections to staff exhibit 3? Has everyone had a chance to take a look at it, or do we want to maybe take it up after lunch when everyone's had a chance to take a look at it?
Oh, there it is.
I don't think we have any objections. I would appreciate the opportunity to review it though. And it strikes me that it can be offered by staff when they put on their witnesses as well. And we will be prepared at that time to address it.
Okay.
We can do
Ms.
it that way.
All right, why don't we go ahead and do that? Thank you, Ms. Regensburg, for the heads up on that.
Thank you. And then we also loaded Mr. Tupler's response to the bench request order as Commission Exhibit 3. We uploaded that yesterday. Thank you.
Okay, well, Commission Exhibit 3, and then what will be admitted.
With Mr. Tupler's, when he does his direct testimony?
Yes.
Okay, thank you.
And then we'll address Commission Exhibit 4 also. I think at the end of the day, but I mean, I have to double check. I need to look at that once it gets marked, and we'll talk about that one maybe after lunch as well. Okay. All right, if all the preliminary matters have been addressed, Ms. Stevens, why don't you go ahead with presenting your first witness, and then Ms. Gonzalez can swear her in.
Thank you, Madam Hearing Examiner. The city calls Lisa LaRock. Lisa, you're muted.
I'm there.
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Good morning, Ms. LaRock.
Good morning.
Give your full name and title for the record.
My name is Lisa LaRock. I'm the Sustainability Officer for the City of Las Cruces.
And did you have the opportunity to prepare pre-filed direct testimony in this case?
Yes.
Is there a document that's been marked City of Las Cruces Exhibit 1 in front of you?
Yes,
And is that your prepared direct testimony?
it is.
Was that testimony prepared by you or under your direct supervision?
Yes, it was.
And is it truthful to the best of your knowledge?
Yes, it is.
Would you, if you were asked the same, well, are there a few corrections that were made on that document since it was filed earlier?
Yes. Yes, there are.
Shall we go quickly through those corrections?
Okay.
Would you turn to page 4?
I am there. On line 11,
And what was done there?
there was a deletion of comments that I made on line 11.
And on page 7, line 7?
Which comment was deleted? What was deleted?
I'm sorry, that wasn't clear. There are brackets with my initials and numbers after them that talk about comments that were on the margins of the document that had been deleted, but the denotation that I made a comment was remained. So it's just 4 brackets that go LL1, 2, 3, and 4.
And we hope that the comments can't be resurrected from the Word version, right, Ms. LaRock?
Yes.
We never know what you can do when you go back and forth. Never know. And would you turn to page 7, line 7?
Yes, there is another example on 7 that says another comment LL5.
And page 16, line 12?
Line 16 or page 16,
Page 16.
Is another one. So you can see I reviewed this very carefully. I have lots of comments, but it's another bracket with my initials.
And now if you would turn to page 30, please.
Oops, I went past. Hold on a second. On 30 is an insertion of the word on line 7. It says the commission should authorize an overly large renewable energy source. It should have been the commission should not authorize an overly large renewable energy project. So insert the word not between should and authorize.
And I'm going to take you now to page 37. Now we're looking at the numbers on the bottom of the page as opposed to the Bates stamps numbered, right? Bates stamped numbering, right?
Oh, okay.
Page 37 of the center numbers.
Well,
or is it
mine is on the
Oh, 37, is it?
I have, it's 40 out of 125, and it's the last line on the document 28, and it's the last line on page 38, which is on line 21, and it said it changed from levelized costs over 20 years. EPE's LCOE figures are significantly understated, not overstated. So I'd like to replace overstated with understated.
And I will ask you to go back to page 37, which is also 39 of
Oh,
120.
you're right. I
And
missed
on line 2, do you see that
Yes,
one?
I apologize. That one is, on line 2, it says the, would further increase the effective average capacity cost to 29.11 instead of from. So replace to with the word from.
And with those changes, would you give the same answers to the same questions today under oath?
Yes.
Okay, so on this page 37,
I-
I'm sorry, could you repeat what the correction is?
The correction should be
Let me see.
delete the word from. So it should read, would further increase the effective average capacity cost to $29.11.
Okay, and I'm sorry, it's on page 39, not page 37.
It is 39 out of 125 of the whole document. It is page 37 if on the printed document.
And one more.
I actually don't even see those comments in the version of Exhibit 1 that I'm.
Oh, this is the version that was uploaded on after the hearing after the first hearing, Madam Hearing Examiner. These changes were not in the original version.
Okay.
Is that possibly what's going on? I hope that other people have this version. I downloaded the whole new set after I think it was on the 2nd or something after the
Okay.
when you gave us to upload the new.
Right. Okay. Yeah.
This is definitely a work in progress, I guess.
Yeah, I see the one here, right? Okay. So we're talking about the one that was uploaded on February 1st. This is going to be, we're really going to have to go over these to determine which of the documents that have been uploaded are the actual exhibits that are being admitted. And I guess maybe the way we need to do that is by date reference for the date that they're uploaded. Because I think the one that I had that I've been working from was the one that's dated January 26th.
Madam Hearing Examiner, that's a good idea, except I've noticed you referred to it as February 1, but when I downloaded it the next day after you gave us the link, it comes through as February 2nd. All my documents are saying February 2nd. So Dropbox is doing some things to the dates that maybe aren't exactly what all of us, I'm not sure whether we're all seeing slightly different things based on the date and what we upload.
So what I'm going to do is this. I don't even, I'm going to create a new Dropbox link for the final of each exhibit to be uploaded because there's too many versions floating around. And so we need a concrete final set for purposes of the transcript. So I'm just wondering then, well, I'm going to check at lunch to see what is in the transcript from that was completed by Ms. Gonzalez. Okay. All right, go ahead with Ms. LaRoque's testimony. Thank you.
With that, I think your answers are true and correct to the best of your knowledge, are they not?
Yes, they are.
And you'd give the same answers under oath today.
Yes, I would. Will.
And with that, the city passes Ms. LaRoque for cross-examination. Thank you.
All right, so we'll start with El Paso Electric. Mr. Wexler.
Thank you, Madam Hearing Examiner. Good morning, Ms. LaRoque.
Good morning.
Unfortunately, Ms. LaRock, due to the nature of your testimony, I have to start with your training and experience so that the hearing examiner has some context. And so we've done this before. Neither one of us particularly likes it, but you have not worked for a utility, is that right?
No,
And you've never operated a utility?
no,
You've never done planning for a utility,
I've helped Las Cruces Utilities.
but not for a utility regulated by the Public Regulation Commission.
No,
And the city does not have service obligations for all of its citizens, is that right?
does not have service obligations? No,
You have a degree or 2 degrees, I think, in natural resources, is that right?
yes,
But you're not an engineer,
no,
and your education is not in a utility related subject.
my pragmatic education is,
In other words, your work experience.
yes,
And you cover that in your testimony, CLC Exhibit 1. And I'll confirm the areas that you're not an expert in as relevant to your testimony. And that is, you're not an expert in electric power generation
no,
or electric power transmission
no,
or electric power distribution.
no,
And you're not an expert in electric systems operations,
no,
electric system planning,
no,
energy procurement.
yes.
Can I get you to look at EPE Exhibit 11, please?
I'm sorry, I don't have access to that exhibit.
I'm going to read to you then from a line there. And I'll be looking at EP, what's been previously marked as EPE Exhibit 11 at page 4 of 16. And then if I'm using the transcript sites, it's in the upper right-hand corner, page 227. And I'll read this to you, Ms. LaRock, and see if you recall giving this testimony. First, let me just ask you, you recall that you gave testimony in case number 19-00348-UT.
Yes,
You were asked this question, you're not an expert in fuel supply and procurement, purchasing, or selling of energy, is that right? Answer, procurement of energy? Question, procurement, purchasing. Answer, I have had experience. Question, would you consider yourself an expert in that field? Answer, I can consider myself knowledgeable, not an expert. Do you recall giving that testimony?
I'd agree with that.
Now, we heard testimony earlier in the case that the company used Plexos portfolio modeling to evaluate the RFP bids. Have you ever had experience operating Plexos?
No,
You're familiar with the term lowest cost of energy, or LCOE?
yes,
How would you define LCOE?
it is the cost of energy over a 20-year period, a levelized cost of energy, using most often the reference that's used as Lazard's table.
As of 2020, when you gave that testimony I just referred to, you had never calculated an LCOE, is that right?
That's correct.
And I assume you'll agree with me that you're not an expert in calculating LCOEs.
No,
Turning then to your testimony in REA compliance. If you turn please to what's to CLC Exhibit 1, and I'll use the small Bates numbering in the lower left-hand corner just to make sure we're on the same page. So this is 3 of 125. Let me know when you're there.
you want
I'm looking. Yes, please. And I'm looking at the question that starts on line 9 and it continues the rest of that page, it spills on to page 4.
Mhm.
And as I understand that, this is the summary of your position in this case, is that right?
Yes,
In essence, you believe that the Carne project is too large and the battery's not needed, is that right?
yes,
So I want to discuss those issues one at a time. And I'll start with your contention that the Carne project is too large. And here, the specific testimony you give is at page 3 and lines 12 through 17. And you say it would, and I'm picking up your language here, it would generate renewable energy greatly in excess of the amounts needed to satisfy EPE's obligation under the New Mexico Renewable Energy Act, to procure at least 20% of the energy it sells to New Mexico customers from renewable energy resources through 2024, and at least 40% of its resources through 2025. You see that testimony?
yes.
And later in your testimony, we don't need to look at it unless you'd like to. You actually discuss the REA, is that right?
Yes,
Just for clarification purposes, the city does not have to comply with the REA.
no,
But the city does support the REA, right?
yes,
And it supports the goal of zero carbon by 2045.
yes,
In fact, in your testimony, you discussed several initiatives of the city to reduce greenhouse gas emissions, right?
correct.
You recognize that the city depends on EPE to meet some of its own reduction goals, is that right?
Yes,
And you personally have testified before the commission that you support renewable energy projects.
I can't say that yes, only with the caveat that it is a cost-effective system.
And yet here you are today, you are opposing a renewable energy project, is that right?
Sadly, yes.
On page 15 of your testimony, again, using the lower right-hand numbers, and I'm looking here at lines 11 through 14, there you include the RPS requirements. You see that?
Yes,
And so we know 40% by 2025, 50% by 2030, 80% by 2040, and 100% by 2045, right? Is that
Yes.
right? Do you have EPE exhibit 13 in front of you?
no,
This is testimony from your from case number 19099 UT,
okay,
which was the EPE 2019 RPS plan case. Do you recall giving testimony in that case?
yes,
And in that case, you were also offering
I'm going to object at this point that Ms. Rock is entitled to see the testimony that she's being referred to, instead of having Mr. Wexler describe it. So we have to figure out something to do. Either you provide it to her, or we give her a chance to look at it, or I'll provide it to her. But it's not fair to her to be guessing at what you're referring to.
Yeah, Madam Hearing Examiner, I'd be happy if she were to look at it. My understanding from the procedure order is it was the responsibility of each of the parties to ensure that their witnesses had each and every exhibit available to them.
That was also actually my understanding as well. So I'm not clear on why Ms. LaRock doesn't have these exhibits.
I just didn't open up the Dropbox when I rebooted. And
So you
it
do
is,
have,
And I'll point out that I just went looking for it and you have to go to the earlier, the Dropbox, it's not in the post.
Hmm.
2 sets open myself, one for the post hearing from the previous 2 days of hearing and the original one. So I'm not sure whether Ms. LaRock also has her Dropbox set up in that manner.
Under the circumstances, I think I would delay the process by searching for it. I find that the Dropbox is very cumbersome. I apologize for not having it easily accessible, but I'm willing to try to respond to the question that Mr. Wexler is asking, given the inconvenience.
Madam Hearing Examiner, if you may, I will send it to her by email.
Okay.
Why don't 13? Is that
Well,
E13 Wexler?
Well, I think we're talking about the cross-examination exhibits. Mr. Wexler would be exhibits potentially 10 through 14. Is that correct? Would those be the exhibits you were anticipating utilizing in the cross-examination of Ms. LaRock?
yes, ma'am.
Okay, so why don't we take a 5-minute break? And
I apologize.
during that time, Ms. Stevens can provide those to Ms. LaRock. All right, so we're gonna go off the
Okay.
record. And we'll go back on the record at 10 a.m., which actually is in 6 minutes. Thank you, everyone.
I have all the documents now.
All right, Ms. Gonzalez. Our court reporter's ready. We can go back on the record. All set?
Yes, I am all set. Thank you.
All right. We're going back on the record in the matter of 22-00093, and we will resume the cross-examination of the City of Las Cruces witness, Lisa LaBrock, by El Paso Electric Council. Mr. Wexler, go ahead.
Thank you, Madam Hearing Examiner. Ms. LaRock, I understand now you have the EPE exhibits before you. Is that correct?
You're on mute.
Yeah. You're still on
Yes.
mute, Miss.
Yes, I do have the documents and they're all open.
Great. And we were talking about RPS requirements, and I'd like to get you to look at some previous testimony that you gave about the RPS requirements. So if you'd look, please, at EPE Exhibit 13.
13. Okay.
You recognize this as your direct testimony on behalf of the city in case number 19-00099.
I do. Yes.
And in that case, you also offered testimony about REA compliance. Is that right?
Yes.
Which is one of the subjects that you're testifying about in the current case.
Yes.
Madam Hearing Examiner, we would move the admission of EPE Exhibit 13.
Okay. Any objection?
The city objects. He doesn't need, there's a lot of testimony. I don't know what he wants to use it for. We're not litigating 2 or 3 cases here. I don't see the purpose of doing that.
Is the entire testimony what EPE is seeking to admit, Mr. Wexler?
Well, that's the parts that we've put in the entire testimony because we were concerned about the, there's an evidentiary rule that requires the entire document to be included. And so out of an abundance of caution, that's exactly what we've done. I intend to ask Ms. LaRock about 3 or 4 pages, which are directly related to statements that she's already made. They're obviously admissions of a party opponent.
My
I'm
understanding of the evidentiary rule is that I get to invoke that if his specific questions raise a concern on the city's part about incompleteness, not that the company gets to slip into the record 3-year-old, whatever it is, 3+-year-old testimony, and which way. And I will note that testimony is for Ms. LaRock's direct testimony. In that case, she filed much more extensive testimony in opposition to the stipulation that the city did not join in that case. And I believe that if we were going to go that way, I would want to have her testimony in opposition to the stipulation, because as I say, it was much more detailed. And in fact, it's that testimony in opposition to the stipulation that raises some of the issues that are in the testimony in this case regarding curtailments and more technical aspects. So I oppose the admission of the entire testimony. I don't oppose Mr. Wexler asking her about specific statements in that testimony and allowing her to explain them in the current context, but the whole testimony I don't think is appropriate.
Madam Hearing Examiner,
Yes.
I can't tell if the city is ruling for or against the rule of completeness. If the city would like us to simply submit the relevant pages of EPE Exhibit 13, we're happy to comply with that.
The city would like the company to cross-examine Ms. LaRock on specific statements so that she can address them in the present context and not just dump into the record old testimony, 3-year-old testimony. It's that simple.
Well, this testimony, you know, is a record from prior proceeding before the commission, and you know, so it is something that of which administrative notice can be taken. So at this point, I think we will go ahead with this, and you know, if any portions of this other than what's used for cross-examination are used for the general purposes of the case, then I think parties can point that out in their response brief. But it's testimony
then again,
that's
I'm
already.
afraid I'm going to have to ask when we get to redirect, pull in her testimony and her hearing testimony and her subsequent testimony in opposition to the stipulation, because this was step 1 in that particular case. And her testimony currently in case 19-00099 UT. And you know, this is an ongoing process. I think that he could narrow it down to really what he wants to ask her about. And I don't know why the company wants the entire document in there.
Well, we're going to proceed with this. And as I said, because it is a record from a prior commission proceeding, we can take administrative notice of it. I would ask, you know, Mr. Wexler, I am trying to keep the numbering of exhibits sequential. Do you anticipate admitting or asking for admission of exhibits 10, 11, and 12? If
Madam
not,
Mayor?
yes, go ahead.
Yeah, in large part, that depends on the testimony of Ms. LaRock. I am content with your ruling that these can be, administrative notice can be taken of these exhibits because they're commission filings. There's very limited parts that I'm actually calling attention to for purposes of this examination.
Okay. So I think that if it would be helpful to have in the record those specific portions, we can do that. But let's wait and see which of these exhibits are offered before we decide on the numbering.
Very well.
So this has been this was what's marked as exhibit 13, Ms. LaRock's direct testimony in 19-00099. So let's move forward with this.
So is it, Madam Hearing Examiner, you're admitting the entire document? Is that what I hear?
No.
That's correct. I mean, but we don't have a specific number for it yet, because what this exhibit it ends up being admitted as will depend on what other exhibits are entered. But I'd like to just move forward at this point with the examination.
Thank you, Madam Hearing Examiner. So, Ms. LaRock, if you could turn please to page, again, marked in the lower left-hand corner, page 54 of 142. And I'll call your attention to lines 4 through 14, which I'll let you get there. Let me know when you are able to see it.
Four through what, I'm sorry?
4 through 14.
Okay.
You can see at lines 4 through 5 here, you say that as amended, the REA now requires steep increases in the percentages of renewable energy provided to New Mexico customers under a rapid time frame. You see that?
Yes.
What do you mean by steep increases?
Well, it went from at 5% increments in the in the earlier periods, before we had this large amendment of 5% increases at 2010 and 15. And then with this other one, with this new addition with the ETA, it jumps from 20 to 40 to 50 with each of the different incremental time periods. That's a steeper increase.
And if you look down lines 10 through 14, there you say that these demanding renewable energy targets, or rather minimum requirements,
I'm sorry, I lost you. There you say that,
quote, these demanding renewable energy targets, or rather minimum requirements, compel electric utilities to approach RPS compliance as the central feature of utility resource planning, not as a discrete annual exercise in incremental additions of otherwise unnecessary renewable resources. You see that?
Yes.
When you're talking about minimum requirements, what do you mean by that?
The minimum, this is, he's demanding. It means that you should not be short-sighted in your planning, that you should look at, you should look down the road at how you are going to meet certain benchmarks. And so, so that's what I meant by minimum.
In another way of saying that might be, in 2025, you have to have at least 40% of your portfolio being renewable resources. Is that right?
I think that's not in complete context. For me to answer yes, there are other requirements in the REA besides just meeting the 20 or 40% milestones. It has to do with reasonable costs. So I can't say that, I can't say yes without context.
Let me ask you this. If in 2025, EPE had 38% renewable resources, would it be in compliance with the RPS?
It'd be closer than it's been in the last 5 years.
And if in, sorry to interrupt, were you finished?
Oh, well, I'm fine.
In 2025, if EPE had 42% of renewable resources, would it be in compliance with the RPS?
Sorry, could you repeat the question?
Yeah, I had asked you earlier if in 2025, EPE had 38%, if it would be in compliance with the 40% RPS requirement. And now my follow-up question was, if in 2025, EPE had 42% renewable resources in 2025, would it be in compliance with the RPS requirement?
Yes, it would.
Turn please to page 64 of this same document, 64 of 142. And
go ahead.
Yeah, whenever you're there, as just as background, I'm interested in the Q&A starting at line 9 on page 64 of 142 and spilling over to page 65, line 13. You're welcome to read the rest of the answer as well for context if that's helpful, but those are the parts. Let me know when you're done reading that.
To what line on page 63 or on 65?
Yeah, on page 6.
Go ahead.
So yeah, so using the left-hand bait stamps, page 64 of 142, line 9, and continuing to page 65, line 13.
Line 13. Thank you. Give me 1 second, please.
Of course.
Okay,
So and I'll direct you for the purposes of this question to page 64, line 19 in that sentence. So I'm going to read it so there's no problems with the record. There is, quote, there is no indication that any analysis was performed to assess the long-term cost effectiveness of procuring larger amounts of renewable energy resources now in light of the increasing RPS requirements over the next 17 years and 4 months of the PPA's terms. You see that?
yes.
And then continuing down, and again, I'm going to just go ahead and read this, lines 4 through 13. Third, EPE and the independent evaluator also overlook section 62.16.5B4 of the REA, which allow utilities to bank unused RECs for up to 4 years. Not only did EPE fail to consider the value that larger, lower cost per megawatt hour proposals would have in providing contemporaneous renewable energy and RECs after the RPS rises to 40% on January 1st, 2025, and to 50% on January 1, 2030. They overlooked the very real potential that procuring a larger quantity of renewable resources now could help EPE to postpone the date by which it must place into service the next set of renewable resources needed to satisfy the rising RPS, or at least to reduce the size of the next group of renewable resources that EPE will need to procure to comply with the RPS. And so to put that in context, Ms. LaRoque, in this testimony that we're reviewing from case 19-00099 UT, you were criticizing EPE for failing to evaluate a larger project, right?
I think that the word that is that you didn't describe is a larger, lower cost per megawatt hour proposals. And that is the objection with the Carney plant facility that is now being proposed. So I think that my point still holds, given that Carney is so expensive.
Now, and we'll get to the RCT in a moment, but you will agree with me, I read your testimony correctly, right?
Well, yes, you read it verbatim.
And in this case, you're asserting that the Carney project is too large, right?
It's too expensive. And it's not needed for meeting the REA.
Right. Your testimony on page 1 was it would generate renewable energy greatly in excess of the amounts needed to satisfy EPE's obligation under the REA, right?
Yes.
Now, of course, you're familiar with the fairy tale of Goldilocks and the Three Bears. And so my question to you is, what do you consider to be the just right size of a renewable project for EPE?
I'm sorry, your reference was unusual. I think the just right size has to do with balancing many variables in its procurement. So I think the just right size isn't about just the size. I think it's also factors in the costs, all of the costs that are involved in the purchase and operation of the system. So what has been problematic in this case is the fact that we, and I understand the challenges of this new endeavor for EPE, but there are many other variables in the costs that haven't been considered before that are now being considered and not being consistently considered. So it's really difficult for the ratepayer and for those of us who are speaking on behalf of the ratepayer to be able to understand what the overall cost will be. And so it isn't the size per se, but it's the cost per megawatt hour. And that is usually a variable that the larger the scale, lower the cost, but that isn't necessarily the case because your IRA figures are much low. I mean, the integrated resource plan figures are much lower than what this system is costing.
That's helpful. So when the hearing examiner goes back and reviews your testimony, she should understand that when you're discussing the Carne project, it's not the size per se, to use your words, but it's really the size as it relates to the cost of the project that's a concern to you.
Yes.
Now, you understand that when EPE puts out an RFP, it can only evaluate the bids that are actually submitted.
Yes, but I also understand that when you write an RFP, that there are certain conditions that you can put on that help the responses that you get in the proposals.
I also want to say, as we sort of finish up a discussion of the just right size of a project, now I assume the city has no interest in attempting to EPE to micromanage EPE as it is compliant with RPS.
Not to micromanage what? I'm sorry, could you tell me again?
Yeah, the city doesn't have any interest in micromanaging EPE's compliance with the RPS, I assume.
I don't look at it as micromanaging. I feel that this process that we have at the Public Regulation Commission is a necessary project for checks and balances when working with a monopoly, and that this is, this like the transportation, renewable energy, grid management, all of these things we're in a very significant time right now, and there are a lot of new things that we're learning all the time, and so we serve, those who testify serve to assist El Paso Electric in bringing out factors and points that should be helpful in your determining what are criteria that you need to use in your selection. I don't perceive it as micromanaging. I think that we all have a vested interest in finding the ideal or closest to ideal installations that we can. So that's why I was surprised that you referred to the case 19-00099, because it shows the evolution of our understanding today about what sorts of things should be considered in selecting installations. So so I think that it's not micromanaging. I think it should be helpful.
You do recall, I'm sure, that you were criticized by hearing examiner Hurst in case 348 for your testimony because she saw it as trying to micromanage the utility.
Objection. What are you? There's no foundation for this.
Well, I'm gonna allow it. Go ahead and respond to the question, Ms. LaRoque.
I don't remember that, and nor was it ever my intent.
Just to close that loop, let's go ahead and look at EP Exhibit 11. This is the transcript of your testimony in that case. Let me know when you have that open and I'll direct you to the page 19.
Just a minute, please.
Wait, what page, Mr.
I don't have
Mr. Wexler?
11. I have exhibit 10.
It's exhibit 11, page 9, and then of the hearing pages, Madam Hearing Examiner, it's
Oh, I see it.
page 247, line 16 through 248, line 2.
Anastasia, I'm sorry, I don't have exhibit 11.
Okay, so which, I can share my screen with this.
Thank
Which,
you. I apologize.
that's okay. Which page is it, Mr. Wexler?
On the bait stamp, it's page 9 of 16. On the transcript, it's page 247 spilling into 248. And once we have
Pardon me, this is exhibit 11?
EPE 11.
Because I opened it and it's 16 pages. Page 1 is 16, and you're referring to page 19.
Well, it's page 9, I thought we were discussing page 9 of 16 on the bait stamping, and that within that page, there's 4 pages of testimony presented.
So do
you see it on the screen, Miss LaRock?
No, I'm sorry, I don't. Oh, wait a second. Hold on.
So
I don't see it on, let me see. I don't see it on the screen, I'm sorry.
Here it is. Okay, it should now be visible on the screen.
I do see it.
Okay, so page 247 is the page I'm cursoring, and then continuing to page 248.
Again,
Is this the portion, Mr. Wexler, that you were referencing?
It is, Madam Hearing Examiner. So I'm starting at line 16. I'm going to go ahead and just read this short section, and then we can move on from this. It's a minor point, but Ms. LaRoque, we can see here line 16, and I'll just ask you to read with me. Hearing Examining Hearst, right, but I'm just saying the city doesn't have the obligation to serve reliable electricity to its citizens, does it? Answer, not at this juncture. There is no opportunity for that. There's only net metering now. Hearing Examiner again says, well, if you don't have that obligation to reliably serve, how can you come in and, it just really seems like the city is trying to micromanage the utility and trying to tell them when the city can't stand in the shoes of EPE. Did I read that correctly, Ms. LaRoque?
Yes.
All right, let's turn to a different subject, and I'll direct you back again to page 3. Here, we're looking at lines 17 through 19, and this is your testimony having to do with the battery. Let me know when you have that before you. This is CLC Exhibit 1.
Oh, okay, hold on.
Apologize, Madam Hearing Examiner, we can take that down if it's okay with you.
Yeah.
I'm on 1. What's the page, please?
Page 3 of 125, lines 17 to 19.
I'm sorry, please repeat it.
Page 3 of 125, lines 17 to 19.
Okay.
This is your testimony that the company hasn't demonstrated the need for the battery, right?
Yes.
In previous cases, you've been supportive of battery storage as necessary to comply with the REA.
Correct.
And you've said that battery serves as an important buffer between electrical generation load in the transition to renewable energy.
Correct.
You said that battery, and this is, I don't know that we need to look at it, but you said that battery serves as an important buffer between electrical generation and load in the transition to renewable energy. Does that sound right?
That is correct.
You've also said that battery storage is a potential solution to curtailment.
Yes.
Let's turn to page 20 of your testimony, again, using the lower left-hand numbers. And here you begin a section of your testimony about EPE's past compliance with RPS requirements. Is that right?
I'm still trying to find the pages. Give me 1 second, please. Okay. What line, please?
Well, I'm looking at the starting at line 9 and the next section, and my question was just general, this section is about EPE's past compliance with RPS requirements.
Yes,
And in fact, on line 10 to 11, you talk about what you term EPE's past failures to comply with the REA. You see that?
on line 10 and 11 of page 20.
That's correct. It's in the heading.
Oh,
Says-
yes, yeah, okay, I was looking in the body.
And then if you look to page 23, please. And here I'm looking at lines 2 through 6. And where you're talking about the outcome of case 19-00099 UT. You recognize that in that case, the commission approved the stipulation,
Yes,
and by doing so authorized the use of retroactive recs.
yes,
And now, to your knowledge, the commission has never issued an order saying that EPE is out of compliance with the REA, right?
It is my understanding that there is an expectation that you would be reaching, you would be at 20% during the period, during the interval before, from 2021 to 2024. I understand that you have, that El Paso Electric has received permission to use future recs to compensate for its inability to reach the milestones on its own planning.
And so my specific question is, the commission has never issued an order saying that EPE is out of compliance with the REA, right?
No, it is a new area for the commission, so it has no precedence to be able to say that at this juncture.
Let's turn to page 34 of your testimony. And you're beginning a discussion at line 16 about the costs of the procurement and whether those are reasonable. Is that right?
Yes.
And you use, and if you want to look at the next page at lines 17 to 18, you can see that you use the reasonable cost threshold, or RCT, of $60.
Mm-hmm.
Now, we already talked about your experience with LCOEs, and to be clear, in this section of your testimony, you're talking about LCOEs, right?
I'm talking about LCOEs in the context of being able to calculate all of the variable costs that that are being charged in the operation of a system, and how those would impact the overall 20-year costs. So I'm not talking about calculating the LCOEs themselves. I'm talking about our ability to accurately, the ability for EPE to accurately represent the LCOEs, given that there are so many other costs that are being added to the operational costs, like the loss of energy with round trips, for the storage, the additional costs, surcharge that's being put on by the solar output payment rule, how often curtailment is going to occur, how costs are going to be distributed amongst how I'm just trying to remember all the things that are in there. The change of prices because of lithium and other batteries that was still even up in the air. I'm just saying that there's a lot of variables that we are now beginning to realize in their full force, and that it's difficult to be able to calculate, it would be difficult to be able to calculate accurately the LCOE. And so that was the point of that.
Yeah, so in other words, you're talking about the components of what goes into properly calculate the LCOE.
That's correct.
And you assert that for purposes of evaluating the RCT, you should include round trip efficiency losses, adjustments for round trip efficiency losses.
I think it influences the price that we end up paying per megawatt hour.
You also assert that the cost for purposes of evaluating the RCT should include adjustments for curtailment.
They also affect our price per hour.
Now, in some parts of your testimony, you cite to specific statutes or regulatory provisions. Is that right?
Yes.
But you don't cite any specific regulatory provision or statute for the idea that the LCOE calculation should include adjustments for round trip losses and planned curtailments, right?
What I do refer to later on is some of the challenges that the commission has before it to be able to give direction to IOUs about what to include when reporting out for procurement purposes. And so that was the point, that was the context for that comment.
And let me try and get at it this way. If you turn please to page 61 of your testimony. Again, this is 61 of 125. I'm looking at lines 7 through 10. And here you're quoting section 62.6.3E, which, as you point out, defines the RCT. You see that?
Yes.
And I assume you're also familiar with the rule, the RCT rule, which the hearing examiner referenced earlier, which is 17.9.572.12. Are you familiar with that reg?
Yes.
And if we're looking at page 61, which is the statute, and please bear in mind, I understand you're not a lawyer. I don't mean to be asking you legal questions. I'm just asking you your interpretation. And that is, we see that the statute, it tells us specifically to adjust for inflation after 2020, right? Lines 9 to 10.
Yes.
There isn't any language about adjusting for curtailment or round trip efficiency losses, is there?
They're not in that section, but I think what we're still talking about here is that this is a new law, and we are learning more about it, and it just begs the question what we should be including. Where I think that the black and white interpretation of this doesn't really look at the spirit of, or doesn't look at the full impacts of the decisions that we're making.
To your knowledge, has the commission ever required a utility to calculate the RCT in the way you're proposing?
I can't answer that question confidently.
If you turn back in your testimony to page 39, and I'm looking this time at your Q&A on lines 5 through 17.
So looking for 39.
Sure.
Okay, 39, I'm there.
And just as background, in your testimony, you make the assumption that 100% of the curtailments should be attributed to the Carnate project, right?
That's what I'm assuming, yes.
But you recognize here in the Q&A that we're looking at that might not be a reasonable assumption.
I can't speak to that.
Well, you do say to the question, is it reasonable to assume that the increment in projected curtailments between 2024 and 2026 should be attributed solely to the Carne project? And your answer is perhaps not, right?
Yes.
You've never been involved in utility scale curtailments, is that right?
No.
Will you agree with me that EPE is in the best position to articulate the principles that it would use if curtailments are necessary?
I am not questioning El Paso Electric's decision-making in terms of when curtailments are necessary. My role is to make sure that ratepayers are being considered as in a transparent and honest fashion. And so I am just trying to be able to understand your decision-making process and the veracity of it, so I can feel confident that our ratepayers are being protected.
If you turn to page 41, please.
There.
And here you have testimony about the RFP process and whether it was a competitive process. Is that right?
Yes.
You understand that there was an independent evaluator that was part of the RFP process?
Yes.
And that person, Wayne Oliver, has acted as an independent evaluator for RFPs and procurement processes across the country?
Yes.
On page 43, and
There.
I'm looking at the Q&A that starts at line 4. And there you say, you're answering the question, why wasn't it wise for EPE to seek both capacity and renewable energy to fulfill the 2025 RPS requirement in a single RFP? You see that?
Yes.
And you're critical of EPE for tailoring the RFP to seek both capacity and to satisfy the RPS requirements. Is that correct?
I'm sorry, can you please repeat your question? I lost you there.
I can. My question is that, Ms. LaRoque, you're being critical of EPE for tailoring the RFP to seek both capacity as well as to satisfy the RPS requirements. Is that right?
Only in the context that it is difficult to discern what is for what, and that the Carney project, since it goes beyond the, since it exceeds the renewable energy requirements, one would interpret that it would be for capacity, not for the REA, but because it's been suggested, because it's going to the because it's going to the renewable portfolio standard, it is for that. I interpret it is for that purpose.
You've previously testified before the commission that it is important for EPE to consider both the RPS and its overall portfolio of system resources when it is conducting renewable energy procurements. Is that right?
Yes.
In fact, I'm going to direct you to some testimony in case 19-00099 UT that you gave. Do you have, before you, Ms. LaRoque, do you have EPE Exhibit 14?
Yes.
And if you look with me at page 10.
It starts, oh, okay, sorry, it's weird. Okay. Now I'm sorry, I'm kind of confused at this. Oh, like 10 of 25?
Yeah, the pages are confusing. Let me just ask you first, you recognize this as the transcript of your testimony in case 19-00099 UT?
I believe I do see 10 through 25, if that's what you're asking.
It is.
Okay.
And if you look at the bottom right-hand corner, the transcript page is 140.
Yes.
And then there again, I'll just ask you to confirm this is your testimony. It says question, and was it your understanding that the resources at issue in that proceeding were capacity resources? Answer, this is another problem that I have with the context that you're describing this in. Because to me, separating the renewable portfolio standard requirements and capacity and system, the system planning should all be one. And it's a very short window when we will be requiring a very large renewable energy portfolio as part of EPE's service to us. So it's hard for me to separate them because I think of them together. And as I think you should, EPE should. Did I read your testimony correctly?
Yes.
All right, finally, if you turn to page 57 back in your direct testimony, CLC exhibit 57. Let me know when you have that.
You're very organized. Okay.
And here at lines 20 to 21, you suggest that EPE is again proposing to use RECs to be generated in the future to make up for deficiencies in RPS compliance since 2020. You see that?
Yes.
You heard Mr. Novella testify?
No.
Do you understand, based on your testimony, is it your understanding that EPE is requesting to use RECs in the future to make up deficiencies, that's part of their request in this case?
Yes.
And if one of the EPE witnesses, as well as their testimony, indicated that that was not a request that EPE was making in this case, would you have any reason to disagree with them?
I'm sorry, that was too many double negatives. Can you ask the question again?
I can, and I don't blame you. My question is, do you agree with me that EPE is in the best position to articulate the relief that it is seeking in this case?
No, in the context that, I mean, yes, your strategies, EPE strategies should propose strategies, absolutely. But I think that EPE may not be considering the ratepayers' costs as much as it is considering the stockholders' benefits. And I think it's our responsibility to point out that that planning and management of the installation early in would have been helpful to the process. And now that we're in this uncharted territory, the commission is trying to propose, is trying to accept your strategy of the RECs, but it still doesn't preclude the fact that it's indicative of the planning that has happened to date by El Paso Electric.
Thank you, Ms. LaRocque, for your patience. I have no further questions, Madam Hearing Examiner, and I only offered the one exhibit, which was EPE 11.
And is there
Hold on a
any
second.
objection to EPE Exhibit 11?
Which one? Hold on a second. One is 11. I have
Exhibit
this-
11 is the testimony from 19-00348. And let me open that.
I apologize. I have that backwards, Madam Hearing Examiner. The one that I offered and we
It's
discussed earlier.
14.
That was 13. I think.
14 is the one that we were discussing earlier, which was
Oh, I thought that was-
Ms. LaRock's direct testimony, correct, from 19-00099.
That
dated
you have
8/26 of 20. Is that?
it is, I believe that Miss Stevens is correct that it looks to me to be Exhibit 13, page 1 of 42, and on my
Page
version.
one of, I'm sorry, page 1 of what? Please repeat.
142, dated July 6, 2020.
And I believe that the hearing examiner already admitted that one over the city's objection.
Yeah, understood, Ms. Stevens. I was just
So I don't know
pointing
why
out.
you're asking right now.
I'm not asking.
I want to make sure you're not asking for something else, particularly that I think they've been transferred.
We're talking about what was marked as. I think that's valuable to be specific,
Sure.
but what was originally marked as EPE Exhibit 13 was offered and discussed and admitted over the city's objection, which is a direct testimony of Ms. LaRock in 19-00099, correct?
That's correct, Your Honor. And the only reason I was raising it now was because you had indicated a desire to discuss the numbering of the EPE exhibits, and you wanted to wait until we saw how many exhibits I actually offered. And I was pointing out only that that was the only one that I had offered. I understood that it was admitted, but if you want us to renumber that, we're happy to do so.
Right, so that would then be renumbered as EPE Exhibit number 10.
Correct.
Okay, and so, you know, what I'm gonna ask the parties to do is tomorrow to upload into a new Dropbox folder a set of properly numbered exhibits for today. We already did that for the previous 2 days of hearing, and so tomorrow we'll do that for all of the exhibits that are admitted today with the corrected numbering, so that we have a, you know, set of exhibits that are consecutively numbered. So that's being admitted as Exhibit 10. What was marked as EPE Exhibit 13.
That's correct, Your Honor, and I have nothing further. Thank you.
Thank you so much, Mr. Wexler. We would now go to the Office of the Attorney General. Mr. Gedko, do you have any cross-examination for Ms. LaRock?
I do not. And I also want to share that Gideon Elliott should be arriving in the waiting room any minute now. I have an 11 o'clock that I have to step off for, and he'll be replacing me.
Okay. He is being admitted right now. Thank you. If Mr. Elliott could enter his appearance for the record.
Gideon Elliott for the Attorney General.
Okay, thank you. The witness was just passed by El Paso Electric, and Mr. Gedko indicated that the Attorney General would have no cross-examination for Lisa LaRock. So we'll move now. Ms. Souls, do you have any cross-examination?
No, ma'am, I do not.
Thank you. Mr. Downs?
I do not, Madam Hearing Examiner. Thank you.
Mr. Herman?
No questions for Doniana. Thank you.
Okay. PRC? Mr.
No,
Borman
no
or Ms.
questions. No
Okay,
questions. Thank you.
thank you. Thank you, Ms. Regensburg. I have a couple of questions, Ms. LaRock, following up on the cross-examination by Mr. Wexler. So there's some discussion of this issue of round trip efficiency losses and solar curtailments. So if you could perhaps describe to me your concern about those two items not being discussed in EPE's testimony or presentation.
Madam Hearing Examiner, as admitted, I am not an expert at calculating the LCOE, but what I understand its purpose to be is to talk about the total costs per megawatt hour over a 20-year period. And it is a reality that just the physics and of moving the energy to a battery and back again causes energy loss. And so we have to pay the generation cost, and it doesn't factor in the point that we have lost energy in the transition. So that's a real loss. So I feel that we're paying more for less energy when we go back and use it. So I feel that it should be included in terms of what the real costs are. And in this case in particular with the curtailment, the stipulation, or the conditions of the contract increase the costs for the solar output payment rate, and so we're paying almost $10 more for that, and that is a real cost if you look at the number of curtailments that would happen over a year and over a 20-year period. So that is why I feel that those actually influence the total LCOE. And I understand that there may not be specific rules for that, but I think that is this is our learning curve now. Everybody is figuring out how to scale up renewable energy and storage, and these are the things that we have to consider on there, and as you know, as we move along and discover more.
Is the city developing its own solar projects at the current time?
Yes, we have right now we have 25% of our energy is through our own renewable energy generation, and there's a small part that is from it's irrelevant. And then we've also in partnership to apply for community solar project. I don't know if that's a spoiler alert, but so we are active in that as well. And the city itself has moved from being a natural gas utility to a natural gas and energy, because it recognizes the need to diversify the types of energy that it produces. And we are looking, and I'm helping with the energy transition plan for that.
Okay. And so what percentage of the city's energy is purchased or derived from El Paso Electric?
75.
75%
right now. Mm-hmm.
And the degree to which El Paso Electric utilizes solar, is that counted for the city meeting its own goals? I guess there's a city council resolution with targets that you're working towards meeting.
Yes, I have developed a climate action plan and a greenhouse gas inventory that has projections about how we would reach our goals. And it's based on an incremental movement towards cleaner energy because of the ETA. And so we did our first study in 2018. We're going to do another inventory in next year. And that will use whatever, well, it'll be for 2023. And that will use whatever the greenhouse gas emissions rate is that was calculated by EPE then. So if EPE is not at 20% or at or moving beyond that, that will reflect in our greenhouse gas emission goals. Or decrease of goal, decrease.
Or decrease, I'm sorry.
Yes, I said that if EPE doesn't meet its goals, our goals are not are lessened as well, because we do have such a reliance on El Paso Electric. So I would really wish that we could meet our goals, but I also recognize that we have a large percentage of people that are energy burdened in the city. 50% of our renters are energy burdened. They pay over 30% of their income on rent and utilities. And then 30% of our homeowners are energy burdened, and they pay over 30% of their mortgage and their salary on the mortgage and utilities. So those are really equally important issues to me as is the greenhouse gases, because we do have a very poor community and energy cost burdens are very real. So I have to look at the cost of this as much as I want to protect the planet.
All right, thank you, Ms. LaRock. I will pass witness to you, Ms. Stevens, for any redirect on Mr. Wexler's cross-examination or my questions of Ms. LaRock.
Thank you, Madam Hearing Examiner. Hello again, Ms. LaRock. I'd like you to clarify some of the answers that you gave to the hearing examiner just now. As far as the city meeting its own generation goal, is El Paso Electric's proportion of renewable energy factored into that number?
So we have a couple of resolutions. One resolution is the city being able to reach 100% of its own generation, municipal generation, by 2050. Then the climate action plan that we have that has goals for the entire city also relies on the energy. So on the energy that from El Paso Electric, unless something else happens.
I still think you quite haven't clarified the city's goals for energy by municipal buildings.
I'm sorry, you cut out. The city's goals for?
The city's goals for energy consumed in municipal buildings and facilities. Does that proportion, does that factor in El Paso Electric's proportion of renewable energy, or is that just the city's own savings based on reduced consumption and city-owned renewables?
I'm sorry, could you reframe the question?
Yeah, I think, well, let me try it a different way. I think that what isn't clear from your testimony is the separation between the community-wide greenhouse gas reductions and the citywide energy consumption, renewable energy consumption. And what I'm asking, whether El Paso Electric's proportion of renewable energy factors into one, the other, or both of those calculations.
Got it. Municipality, our goal is to generate our own energy through renewable sources that we have installed, used, purchased ourselves. That is an ambitious goal that was set a number of years ago, before the Energy Transition Act. So I don't think that there is a perfect interpretation of whether that is really dependent on us purchasing our own energy or relying on other clean energy sources. But the intent was to purchase our own. Now, in the case of right now, just in terms of municipal energy, we are generating 25% of our total needs through our own generation, and 75% obviously would be from El Paso Electric. In the case of our citywide goals, the municipality is really dwarfed in that whole number. We only represent 5% of the total energy used or purchased by El Paso Electric, from El Paso Electric. And so that 95% of the energy that is purchased through El Paso Electric is, we would be relying on both people moving towards clean energy themselves through distributed energy, through their own rooftop sources or through community solar. And if they, and from El Paso Electric. And it is we are, and in calculating our goal, reaching our goals, it is in a large part dependent, our citywide goals, it is a large part dependent on whether EPE meets the Energy Transition Act, the Renewable Energy Act milestones.
Also in response to the hearing examiner's questions, you testified that 25% of the energy is through our own resources, and then you referred to a small part, but I did not, and maybe it was my fear. Did you explain what that small part is?
There's a couple percentage points that is from cogeneration, where we capture the methane from our wastewater treatment plants and use it to fuel the generation of the wastewater system.
Thank you. I'm now turning to Mr. Wexler's questions. He asked you about your testimony, assuming that 100% of the curtailments calculated by the company what were allocated to the New Mexico jurisdiction. Do you remember that line of questioning?
Mm-hmm.
And have you read Mr. Martinez's rebuttal testimony since you filed your written testimony?
I have, yes, I have the new chart, although I can't say that I have digested it fully.
Do you understand that in response to your testimony, EPE did in fact do an allocation so that fewer curtailments were allocated?
I did say that, which only makes me more anxious about what the LCOE ultimately is, or and how having curtailment and round trip in there, especially the curtailment, would influence the overall cost of that. So it was surprising to me to see that it went from what, like 88,000 to 18,000 or something don't have the table in front of me, but I remember it being a very significant shift.
And with fewer curtailments, does that get EPE closer to the 40% renewable energy RPS requirement for 2025 without the Carne project? Potentially.
Yes, because you're losing less energy.
And finally, Mr. Wexler asked you some questions about the idea of allocating of carrying over RECs. I believe he actually read from the statute about the 4-year carryover provision. If EPE were not, if EPE or the commission, if the commission did not order EPE to try to make up for all of its past deficiencies at the earliest possible moment, would it be possible for EPE to bank some renewable energy certificates in 2023 and 2024 when the Buena Vista and Hecate projects come online, and then use them to meet or help meet the 40% requirement in 2025 and possibly 2026?
Yes, and I think what you're saying is, are there other ways of addressing, meeting or coming close to the requirements that negate that won't require that El Paso Electric purchase Carne? If Carne is not considered a cost-effective system, could there be other ways to come close to the goals and look for something that is more cost effective? And I would say yes. I mean, there, terms of sustainability, there's no one more than I who want these goals met, but I want them met in a cost effective method. So the urgency that's happening now is surprising, given that there's been a large period of time that El Paso Electric could have met it, and now all of a sudden it's a great urgency, but it might not be a thoughtful way of approaching it.
Well, thank you very much, Ms. LaRock, and thank you.
Yep, I appreciate it. Thank you. And thank you, hearing examiner, for accommodating my schedule.
Oh, you're welcome, Ms. LaRock. Well, I think that concludes your testimony. So you are released from being available today for any further questions. And at this point, then we would turn to Ms. Souls to present her case.
Thank you.
Thank you, Madam Hearing Examiner. And I will be the first witness. And let's start with, do you want to take me through entering my testimony, or shall I do it on my own?
Shall I swear her in first?
Yes. Why don't we start with having you sworn, Ms. Souls? Thank you. And then I think you can go through the questions with respect to
Very
the
well.
accuracy and of your written testimony.
Raise your hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, I do.
Thank you.
So Ms. Souls, you'd be starting with your testimony is currently marked as Souls Exhibit 1, correct? Your
That's
direct
correct.
testimony.
That's correct. I'm going to start by stating my full name and spelling it. It is Merrie, another word, Lee, and my last name is Soules, Soules. That's Mary Lee Soules. I am currently retired after a career as an engineer and a businesswoman. I do have before me what is marked as Soules Exhibit 1. It is the direct testimony I've previously prepared. I drafted it entirely on my own. And I do have a couple of corrections. On page 13 of 55, I remove a reference to an exhibit that is not attached. It doesn't change any of the rest of the testimony. And then on page 36 of 55, in table MLS-8, the value for total kilowatt hours changes to 336, 349, 317. And with those corrections, if I were asked the same questions today, my answers would be not quite the same because of the evolution of the case and additional testimony that has been submitted as rebuttal and supplemental testimony. But given the same circumstances as when my testimony was prepared, I would answer those questions in the same way. My testimony as presented is true and correct to the best of my knowledge and belief. And with that, I move admission of Soules Exhibit 1.
I can't hear you.
I moved admission of Soules Exhibit 1.
I'm sorry, I wasn't, I think. Ms. Hearing Examiner, were you, I'm not hearing it.
So Ms. Soules, you're saying that your answers would not be the same today.
There has been additional testimony that has been submitted to the record since I prepared this direct testimony, and that changes the answers to some of these questions. In the context of what was available at the time I prepared this testimony, it is true and correct.
Do you intend to address the differences or changes? I mean, I believe this creates a problem with admission of this testimony.
So my experience in past cases has had some similar issues that arose. And I can't change my testimony after the fact because an El Paso Electric witness files rebuttal testimony changing a position or files supplemental testimony in response to a bench request that further changes.
Give me one moment.
Hold on a moment.
So sorry. Turn this thing off. I'm trying to turn it off. I'll just take it up. Give me a second. Something I forgot to do. Sorry about that, you guys. Let me read what I have, okay, Ms. Soules. So my experience in past cases has had some similar issues that arose, and I can't change my testimony after the fact because an El Paso Electric witness files rebuttal testimony changing a position.
That is what I said. I went further and said an El Paso Electric witness files supplemental testimony in response to a bench request that further changes that position. My direct testimony becomes not what I would say at this point in time because of that evolution through this case.
So my question was, do you intend to make those revisions during the course of your testimony?
I did not plan to do that. I assumed that in briefing, I would address the current state of the record and what it implies.
Is there any objection to the admission of Ms. Soule's testimony under these conditions that she's expressed?
Objection.
Hearing examiner, this is Anastasia Stevens. I don't have any objections, but I do think all the testimonies were admitted at the start of the hearing on the first day on January 30th. So I'm not sure.
Well, it
what-
was subject to the affirmation of the
Oh.
testimony, and what Ms. Soules has indicated is that she can no longer
Okay.
affirm that the responses to the questions are the same as they
I
were
see.
at the time.
Okay,
So
so I
now-
did mess up by not asking to readmit Ms. LaRocque's testimony.
No, because she affirmed the testimony as laid out in that exhibit.
And I will say there were some minor changes in our testimony that put us in the same situation as Ms. Soules. I think she has bigger specific numerical ones, but we too will be addressing particularly Mr. Martinez's exhibit VM 1R, I think it was, as opposed to his original exhibits.
Well, at this right, I mean, at this moment, though, we're discussing Ms. Soule's exhibit 1, and the problem of her inability to affirm that testimony today.
Madam Hearing Examiner, Keith Herman
Yes,
with
Mr.
Indiana
Herman.
County. I wouldn't have an issue, but I do think we'd need to identify the questions and the changes in position.
Right.
I would
Would
be
you-
willing to use some of my cross-examination time to dive into some of those issues.
I mean, Ms. Soules, are you able at this time to identify which questions and answers which answers would be revised at this time?
Possibly. They are in regards to the topic of how El Paso Electric proposes to satisfy the renewable portfolio standard in 2023, which changed significantly based on El Paso Electric witness Victor Martinez rebuttal testimony and then supplemental testimony. They would change in regards to how the RPS cost rider is calculated, which has also changed as the result of changes in Mr. El Paso Electric witness. Can someone help me with who that witness was?
Well, I mean, was it Mr. Novella or?
No.
Let's
It
see.
might be Gonzalez.
Mr. Gonzalez, thank you. And his rebuttal testimony and then his response to your bench request have changed the original premise of the proposal for the cost rider.
Well, I can understand how those might impact your testimony. So I'll admit Souls Exhibit 1, but it's going to be subject to correction through either testimony today or whether or not we need to discuss supplemental testimony, I guess, would be the other option going forward. So, okay. Thank you, Ms. Souls. So that will be admitted, but it is going to be subject to correction or supplementation.
Very well. At this time, I'd like to go to Souls Exhibit 4, which is my rebuttal testimony, and it was drafted by me. I don't have any corrections to offer. And if I were asked the same questions today, would my answers be the same? And I believe I can say yes, they would be. And therefore, that rebuttal testimony is true and correct to the best of my knowledge. And with that, I move for admission of Souls Exhibit 4.
Souls Exhibit 4 can be admitted.
Now I have one other request, and that is to formally admit Souls Exhibit 6. This is the unexecuted large generation interconnect agreement between El Paso Electric and what is solar PV, and has been portrayed to me in previous testimony by El Paso Electric as the interconnection agreement related to the Carney project. You had indicated that I could download it as directed by Mr. Hawkins previously and submit it as an exhibit at the point that I offered my testimony.
Is there any objection to Souls Exhibit 6?
Madam Hearing Examiner, we need to take a look at Souls Exhibit 6 and determine whether it's the correct document. I mean, we don't have a witness currently that can provide any kind of foundation for this document, but if we may, give us some time to think about it, and we'll be prepared to talk after lunch.
Okay, we'll do that. Thank you.
Madam Hearing Examiner, may I ask Ms. Souls, I'm not seeing Souls Exhibit 6. Which group was it uploaded with?
I think it was just. Go ahead, Ms. Souls.
It was uploaded 2 days ago. It is in the same place as what was admitted in the first 2 days.
Okay, got you. 2 days ago. Yeah, thank you. I see it now. Too many files.
Okay, so at this point, then we will defer a ruling on Souls Exhibit 6 to give EPE an opportunity to review it. Okay, so then Ms. Souls, if that completes your direct testimony, we would turn to cross-examination by El Paso Electric.
Thank you, Madam Hearing Examiner. Good morning, Mrs. Souls.
That's Ms. Souls, please.
I thought I said Miss Souls, did I not?
I heard Mrs. and I wouldn't want that to be in the record. Good morning.
I apologize. No, I meant to say Miss Souls. Good morning. I'm going to talk, I want to talk briefly with you on 3 issues. I want to talk about your interest in the case, a little bit about your testimony that EPE won't meet the RPS requirements for 2023, and then the relevance of your testimony on retroactive application of RECs in Macho Springs. So let's start with your interest in the case. And in your testimony, you list your address as being on 37th Avenue, West Seattle, Washington. Is that right?
That's correct.
And that's your primary residence?
That's correct.
How long have you lived there?
Since the first year into the pandemic, I am a pandemic refugee.
Understood. And the answer to this question is probably obvious, but EPE does not provide service to your resident in Seattle, right?
Not to my knowledge.
And mine either. And so nothing that happens in this case will impact your bill at your Seattle residence.
So the bill in Seattle is not in my name and I don't pay it and I don't expect that it will.
Do you know what company provides power to your Seattle residents?
I believe it is Seattle City Light.
Have you participated in any of their utility cases?
I've reached out to them, but there's been a pandemic and they have not responded.
I understand that you became a customer again of EPE on November 10th or November 11th, 2022. Is that right?
That's my recollection, yes.
And for comparison, do you know when this case was filed by EPE?
It was filed prior to that.
Now, if I understand your discovery responses correctly, you became a customer of EPE on that date on 3 different accounts. One that's located on Silver King in Las Cruces, one on Juniper in Las Cruces, and one on Merv's Lane Trail, maybe in Las Cruces. Do I have that correct?
That sounds correct to me, yes.
But you don't live at any of those locations.
Those are not my official resident address. That's correct.
Do you own those lots?
I do not.
Who does?
I believe they are titled in my brother's name, and one of them is also in his ex-wife's name, and one of them, I believe, is in his current wife's name also.
But you are listed on the accounts for each of those properties as of November of 2022.
Correct.
But am I correct that you're not the only name listed on those accounts?
That's also correct.
Did you initiate getting your name listed on those accounts in November of 2022?
My brother got married, and therefore that created a whole family dynamic. One of the outcomes being that I am listed on that account now.
I see. Let's see. Have you paid the bills associated with those 3 properties?
I don't understand what you're asking.
Have bills for electric services for those properties been sent to either you or your brother?
They've come to my attention.
And so my question is, did you pay them or did somebody else pay them?
To this point, I have not written a check.
Are each of those 3 properties residences, like for home residences where people live?
Yes, they are.
Are any of them commercial properties?
What do you mean by commercial?
I mean that are any of them being used for small businesses as that term would be defined in EPE's tariffs?
I don't believe so, no.
Staying on the topic of your interest in the case, you sponsor the testimony of Mr. Simpson, is that right?
Yes.
And he takes issue with rate number 3, the small general service rate. Is that right?
He is proposing a modification. Yes, I'm not sure that takes issue is the appropriate characterization.
Okay, so he's proposing a modification, and he's proposing that modification as your witness on your behalf.
Correct.
Are you familiar with rate number 3?
I'm somewhat familiar.
Will you agree with me that none of the accounts we discussed, well, I think you said they weren't small commercial accounts, none of the 3 that are under your name, right?
That's correct.
Are you aware that rate number 3 applies only to small commercial customers?
Yes.
You of course understand this is not a rate case.
Was that a question?
Yeah, my question was, you understand this is not a rate case, in other words, not a general rate case seeking to change the rates for EPE customers?
I understand it is not a general rate case. I also understand that in relation to renewable energy initiatives, that rates can be addressed in a renewable energy plan filing.
In its application, did EPE request a change to rate number 3?
EPE did not.
Did EPE, well, did the notice that was provided in this case identify the possibility of a change to rate number 3?
Not to my knowledge.
Do you know, and I mean, only answer this question if you know, if the rate changes, so if rate 3 changes in the way that Mr. Simpson is testifying on your behalf, will that impact ratepayers that are not part of this proceeding?
So it's my understanding that this proceeding, in particular with my being a party, with Mr. Downs being a party, and with the Attorney General being a party, and with staff being a party, that the entirety of El Paso Electric's New Mexico service territory could and will be affected with what happens here. And that those parties are represented.
What's your understanding of the purpose of a notice?
It is to make public the topics that will be dealt with in this proceeding.
Is one of the purposes to give EPE customers the opportunity to participate if they're interested in the topic or concerned about the impact to their businesses, for example?
That is one of the purposes, as I understand it.
Okay, let's change to the second topic I wanted to discuss with you, and that is the forecast for RPS approval. And as we start the topic, I want to ask you the general question of, you're familiar with the REA?
I am familiar with the REA, the Renewable Energy Act.
And do you have an understanding of the goals of that statute, the purposes?
I believe I have some understanding, given that it's a statute and they don't generally express goals.
What's your understanding of the purposes or goals of the statute?
My understanding is that it lays out a path for attainment of an energy transition for New Mexico.
Do you support the goal of an energy transition to renewable energy for New Mexico?
I'm sorry, I don't understand that question.
Do you think it's a good idea for New Mexico to transfer, to change to renewable resources to provide energy to its citizens?
I do believe that New Mexico needs to leave behind the burning of fossil fuels, the dirty energy production of electricity, and move towards clean and renewable energy.
You're familiar with the RPS requirements?
Yes, I am.
Do you support those? Do you think that's a good idea?
They're in the law, and I'd rather not be in the position of casting judgment on the law.
All right, fair enough. In your Souls Exhibit 1 at page 9.
Give me a moment to get there, please.
Sure, let me know when you get there.
We've talked, all right, when you say page 9, all right, looks like my date stamp matches my other. Give me a moment,
It does.
please.
I thought that was quite well done, and in the future, I plan to make sure that EPE does that as well.
All right, which line on page 9, please?
I'm looking at the answer on lines 1 through 9.
Okay.
And I'm in particular, I'm curious here at line 1 and again at line 2, and frankly, throughout your testimony, you suggest that EPE misrepresented its current and future status. And my question is it your contention that EPE is intentionally misrepresenting its status?
It's my conclusion that EPE is either intentionally misrepresenting its status or has been inattentive in how it's doing its forecasts.
You talk about in the same section on line 6, and the sentence starts on page 5. You say EP has failed to satisfy the requirement of the REA to make reasonable and consistent progress over time. You see that?
Yes, I do.
How do you define reasonable and consistent progress?
We are here in 2023, and the last time El Paso Electric added renewable energy was in 2018 with the 5 megawatts at Holloman Air Force Base. El Paso Electric had a plan to bring on a significant amount of renewable energy as of May 1st, 2022. And to the best of my knowledge, that still hasn't happened. A couple of weeks ago, in the first days of this hearing, we had a conversation about El Paso Electric representing that it was likely that Buena Vista 2 would commence commercial operations before the end of January. We confirmed that that did not happen. And so there's still a plan or a forecast, but there has been no additional renewable energy since 2018.
And I think you answered the question specifically with reference to El Paso Electric, and I meant to be asking a more general question, which is, how do you understand the phrase? What does it mean to you to make reasonable and consistent progress in a general sense?
Well, I just gave you a characterization as to what it means to me. It's not clear to me that that's well defined anywhere that I can grasp more meaning than what I just described.
So you would understand that just with reference to EPE's specific circumstances.
I'm specifically talking about El Paso Electric. There is this phrase out there at this point. I think it's in rule. I don't believe it's in statute. But what that phrase means, I've never seen it as being putting forth a plan. I understand it to have to do with actual progress.
Let me ask you this. If the Buena Vista projects and the Hecate projects had gone online as was anticipated by El Paso Electric, would El Paso Electric have been making reasonable and consistent progress under those circumstances?
Without doubt.
If you turn to page 22 of your testimony, I think this is your, what I understand to be your alternative to table VM3. Is that, do I understand that correctly?
I'm getting to page 22.
Sure.
All right.
All right, I guess the table is on 23. You have testimony about it on 22, and then it's 23 that the actual table resides.
Yeah,
And so that table MLS 5 on page 23, that's your alternative to table VM3, is that right?
no.
What is MLS 5, table MLS 5?
Table MLS 5 takes the breakdown of the lump category and Mr. Martinez table VM3 that is RPS energy approved resources.
So then your alternative table would be on page 24. Is that how you would describe that?
That's correct. And this is one of those areas that my testimony would change based on subsequent testimony submitted by Mr. Martinez.
Yeah, I understand your point about your testimony might change. But I mean, you've been involved. How many cases have you been involved in at the commission?
I was reviewing this testimony and I think I said 37.
37. And in each one of those cases, there's a process by which there's direct testimony, responsive testimony, or direct testimony from interveners and staff. And then there's rebuttal testimony, right?
Yes.
And oftentimes there's supplemental testimony. Would you agree with that? And so I don't know, others might ask you, but I'm reluctant to ask you about the changes that you're making because it's sort of a little bit out of the ordinary procedure. So that's why I'm not going to ask you specifically about your changes. I'm certain that you will be asked and have your opportunity to give that testimony. Let me ask you about on page 22 at lines 8 through 21.
Give me a moment.
Sure, you bet.
Okay.
And these are your assumptions for your SOL's forecast for RPS energy approved resources, right?
Yes.
Can you tell me what's your assumption as to the RECs from BV2? And if you need a more specific question, it's what's your assumption as to when BV2 would come online?
I did not change the assumption related to BV2 when I created this table of my assumptions. That change about when BV2 would come online was introduced by Mr. Martinez in his rebuttal testimony.
I see. So that's one thing that might affect your forecast.
Mr. Martinez's testimony, as I recall, was very clear about he's assuming that BV2 would come online before what's represented in the proposed amendments.
Yeah, I think he said by April 1st is the date I recall.
I recall that as well. He said that was the conservative estimate and that he expected it to be online before that. Mr. Hawkins perhaps framed that somewhat differently.
Yeah, and then at least Mr. Hawkins, and I don't recall Mr. Martinez, but Mr. Hawkins thought that BV1 would also come online prior to the COD that's in the current amendment. Did you understand that to be true as well?
I did. However, Mr. Hawkins offered no numbers. He was talking in very big generalities, and the delay from January 1st he represented as being related to additional testing. It was very general.
Am I correct that if BV1 and BV2 come online earlier than your assumptions, it will affect your forecast?
So with Mr. Martinez revisions to his table VM-3, he made two significant changes. He removed the assumption that community solar would contribute to the renewable energy requirement in 2023. And he assumed that Buena Vista, whether it's 1 or 2, would come online earlier than the proposed commercial operation date, and that those additional RECs that would be generated by them coming online earlier would generate sufficient RECs that the requirement of 20% in 2023 would be satisfied.
And I understand that to be Mr. Martinez's testimony. My question was, would it affect your forecast if BV1 and BV2 came online earlier?
It would certainly have me recreating numbers, and this may be part of what will have to be required if I'm required to change my testimony. Though that seems to me that it will create a significant amount of confusion.
All right, so let's turn then to the third question or issue that I wanted to talk about with you very briefly, which is your understanding of EPE's proposals in this case. And to do that, let's look at page 25 of your testimony. And I'm looking specifically at lines 4 through 10. And if you're there on line 6, you say that it would be a huge mistake for the commission to continue to authorize the retroactive application of RECs. Do you see that?
I do.
You understand the commission previously authorized the retroactive application of RECs.
I understand the commission has twice previously authorized the retroactive application of RECs.
You were present for Mr. Novella's testimony, were you not?
I was.
You understand that EPE is not making a request in this case for retroactive application of RECs?
I do.
And then if you turn to page 26 of your testimony, and here, this is the testimony about Macho Springs. And so it starts on line 1 and it goes down to 17, and then your alternative proposal comes after that. You see that?
I do.
And so again, based on Mr. Novella's testimony, you understand that EPE is not seeking approval of Macho Springs in this case to comply with its RPS obligations?
I certainly hope that's the case. And it seemed that the testimony would support that.
Thank you, Ms. Souls. That's all the questions I have. Appreciate it.
I think that this is, well, let me see. Does the Office of the Attorney General have any cross-examination for Ms. Souls?
No, Madam Hearing Examiner, thank you.
City of Las Cruces, do you have any cross-examination?
No, Madam Hearing Examiner, thank you.
Mr. Downs, do you have any?
I do not, Madam Hearing Examiner. Thank you.
Mr. Herbin, do you have cross-examination, or I know you offered to try to identify to clarify Ms. Souls' direct testimony?
Yes, I had some limited questions around that and some other foundational questions.
Okay, well, why don't we go ahead then and take a lunch break, and we'll start then with you, Mr. Herman?
That would work for me. Thank you.
So we will go back, we'll go off the record now for lunch and we'll come back on the record in an hour, which would be approximately 12:55.
Madam Hearing Examiner,
Yes.
just, I don't know that this needs to be on the record, but
You want me to
my
go out?
counsel, co-counsel and I will have to be excused until at least 1:30.
Okay, so well, on the record, I will allow that, and of course, with the understanding that you would not be able to object to any testimony that's elicited during the period of time that you're not participating in the hearing.
Thank you.
You're welcome. Okay, we will then now go off the record until 12:55. Thank you.
Thank you.
for pool permit because it's changed since the time that she submitted it for purposes.
Madam
based
Hearing
on-
Examiner, you are not muted.
But then what was in cross-examination
All right, good afternoon, everyone. We are going to go back on the record in 22-00093, El Paso Electric's application for approval of its resource plan. We are going to get started with cross-examination by the city of Las Cruces, or I'm sorry, by Doña Ana County of Mary Lee Souls. Mr. Herman?
Thank you, Madam Examiner. Good afternoon, Ms. Souls. My name
Hello,
is
Mr.
Keith
Herman.
Herman. Oh, I'm sorry.
Hello, Mr. Herman.
My name is Keith Herman, and I represent Doña Ana County, and I had some questions about your testimony provided in this case. So going back to your initial admission or request to admit MLS 1, is that your direct testimony?
Yes, it is.
You had stated that some of your responses had changed or would change based on new information. Can you please identify what questions those are?
Well, throughout my testimony is organized first by addressing El Paso Electric's achievement in 2023 of the 20% RPS standard that's required. So when I wrote this testimony, I had available to me the testimony of Mr. Victor Martinez, and specifically his table VM3, where he made some specific assumptions about community solar in 2023. And he made assumptions about the Buena Vista projects coming online according to the proposed amendments, which would have been June 1st of 2023. He has since changed those assumptions. He changed it in his rebuttal testimony. He made further adjustments in his supplemental testimony. My testimony would be different in that section based on the evolution of Mr. Martinez's testimony, but my testimony is accurate based on the facts that I had at the time that I submitted it and swore to it.
Let me back up. I'm sorry, I might have gotten ahead of myself. What did you base, what items did you review in drafting your direct testimony?
I reviewed El Paso Electric's application filing, which included direct testimony of Victor Martinez, of George Novella, of Rene Gonzalez, and of Wayne Oliver. They made various references to things like El Paso Electric's most recent accepted integrated resource plan. There are other cases and filings in the PRC docket that I also referred to.
So you reviewed the application, the testimonies contained in the application, and other cases referenced in El Paso's application?
Not just what they referenced, but what is in the record of El Paso Electric's cases. So I went beyond just the references that they made.
Do you know what cases those are?
Their previous Renewable Energy Act filings, that would have been 19-00099-UT, 21-00111-UT. The case that's the other one of the long-term purchase power agreements, 19-00348-UT, 19-00349-UT, which was the Newman 6 case, which was related to requirements for capacity approvals. Off the top of my head, those are the ones I specifically recall. It was not just what El Paso Electric referenced in their original filing and application.
And that's all you can recall at this moment?
Yes, sir.
So going back to what you had mentioned about information from El Paso Electric supplemental and rebuttal testimony, you mentioned that that would change certain positions you took with regard to the 2023 RPS standard. Do you recall that?
I do recall that.
How would your positions change now that you've had an opportunity to review the rebuttal and supplemental testimonies?
So with the changes that Mr. Martinez evolved into regarding his forecast of the number of RECs that El Paso Electric would be able to retire in 2023, that seemed reasonable to me, not the community solar and earlier commercial operation dates for Buena Vista. Those calculations would then lead me to conclude that if that happened with Buena Vista, was reasonable that it could happen with Buena Vista, then in all probability, El Paso Electric would satisfy the 20% RPS requirement for 2023. And I would have written my testimony accordingly.
With respect to your direct testimony, besides the change you just identified with respect to the 2023 RPS standard, are there any other changes in positions based on the rebuttal and supplemental testimony?
Yes, there are. There's another section to my testimony that addresses the calculation of the RPS cost rider being proposed for 2023.
Can you direct me to a page?
Give me a moment, please. That section starts on page 28 of 55. And here I'm addressing the proposal that was in the original direct testimony of EPE witness Rene Gonzalez. And Mr. Gonzalez subsequently changed his approach to the calculation of the RPS cost rider. And with that change, I would certainly have written this section differently.
And how would it have been different?
I'm not sure at this point because Mr. Gonzalez in his updated, I believe it was his rebuttal testimony, and then also in his testimony under cross-examination and in response to the hearing examiner, my sense right now is that those numbers have changed in ways that I don't yet totally comprehend.
Okay. So we've identified changes to the 2023 RPS standard, the 2022 RPS cost rider. Are there any other changes?
So the third section of my testimony addresses El Paso Electric's request for approval of the Carnate project.
And on the third section of your testimony, you're referring to page?
I'm on page 37.
So section Roman numeral 4.
Yes, sir.
And that's just because the first section is your introduction, correct?
That's correct.
And how would your testimony in response to this discussion change based on what you've heard at this hearing?
When I wrote this testimony, I had reviewed the proposed purchase power agreement in the proposed energy storage agreement. But I didn't have access to the interconnection agreement that was discussed with Mr. Hawkins as part of the hearing. That interconnection agreement is what I have offered as Soul's Exhibit 6 that the hearing examiner had previously indicated I could introduce when I introduced my testimony today. And that interconnection agreement would have had me prepare this testimony differently.
I do want to get to MLS 6, but I want to close this loop here on other changes to your testimony. Are there any, so beyond the cost rider and the RPS standard and information with regard to the interconnection agreement for the Carne project, are there any other changes in your direct testimony that you would like to identify?
There are related changes to the conclusions and recommendations, but I've always thought that those are better addressed as part of briefing. And so I apologize for this difficulty. I take seriously when I swear that I'm going to respond with the truth as I understand it. I could absolutely represent my testimony as being true and correct as of the point in time that I submitted it and affirmed it, which seems to be the standard for these proceedings.
I agree that I think briefing would probably be the best place to summarize the proceedings here. But while we're here, with regard to your rebuttal testimony, what did you review in drafting your rebuttal testimony?
When I drafted my rebuttal testimony, I was addressing testimony that was filed by parties other than El Paso Electric. And so if you'll give me a moment to pull it up. So I address direct testimony that was filed by the PRC Utility Division staff, and I addressed testimony that was filed by the New Mexico Attorney General witness. And as I said, I don't believe that that testimony would change. I haven't experienced a difference in any of their testimony or cross-examination since I wrote and filed and affirmed this rebuttal testimony.
Okay. And then with regard to MLS 6, could you please identify that exhibit?
That is the unexecuted large generation interconnection agreement that I was directed by witness Hawkins to the FERC website. That this became effective late in January, shortly before the first 2 days of hearing. And so it is the interconnection agreement related to the Carne project.
And where did you obtain this document?
On the FERC website as suggested by Mr. Hawkins.
And when did you access this?
A few days after that second day of hearing in this case.
So that was, bear with me. We did this hearing on the 26th and 27th of January.
On the
30
30th
and 31.
and 31st.
Oh, thank you. So sometime in that week you've accessed that?
Yes.
And upon review of that, has that changed any of your positions taken probably with respect to section 4 or any other section of your direct testimony or rebuttal testimony.
Yes, with respect to section 4, I would have responded differently regarding my understanding of the commercial operation date that had been portrayed as May 1st of 2024 for Carne, and I would have responded differently regarding my understanding of the costs related to the Carne project.
And how would your testimony have changed with respect to the commercial operation date?
So the interconnection agreement includes a milestone that is the commercial operation date. It's on page 100 of 277 in Souls Exhibit 6.
Bear with me. I am scrolling. Okay, and you're referring to the, looks like there's a table with a milestone for commercial operations date.
Correct. And what it says here is that the customer, which would be this organization's solar PV development, NM, has identified a desire to achieve commercial operation on December 31st, 2024. However, the transmission provider, which is El Paso Electric, estimates that after any and all land acquisition easements and environmental services and permitting have been obtained by the interconnection customer and transferred to El Paso Electric, the engineering, procurement, and construction necessary for all network upgrades in the interconnection customer's NRIS cluster is estimated to take 54 months. As 54 months is equivalent to 4.5 years, I struggle with what that means about when Carne actually could be experiencing a commercial operation date.
I'm sorry, what
Certainly.
page are you referencing, Ms. Souls?
I'm on page 100 of 277.
Thank you.
If this was filed in November of 2022, 54 months from 2022, if the customer provided all of those things to El Paso Electric, is 4.5 years. That takes us into 2026, 2027, not 2025. Or if I work backwards from the date, then all of those acquisitions and permits being transferred to El Paso Electric would have already happened prior to when the RFP process was engaged in. My testimony would have been very different.
And so you identified changes that would have arose from the changes or from the commercial operation date information you've received. What you also alluded to cost of the Carne project.
That's correct.
Can you identify the changes there? And
so on page,
what relevant pages of MLS 6 that pertains to?
Page 109 of 277. I'm still getting there, forgive me. There's a table C-13. Total cost per cluster project.
I'm sorry, please repeat.
Total cost per cluster project. From reading this contract, LA 130S represents the Carne project. And there's a total there of $23,330,739 for the interconnect. So this expanded my concept of the cost that the commission would be approving if they chose to approve the Carney project.
I'm sorry, could you restate that, please? You cut out for a moment.
Of course. This changes my understanding of the cost associated with the Carney project.
And how does it change your understanding of the cost?
We have talked about the Carney project and the PPA cost of $29 and something per megawatt hour, and the energy storage cost of 10 something per, forgive me, I'm going to get the units wrong. We've talked about the cost with each of those contracts. We haven't talked about this more than $23 million for the interconnection. And therefore, my testimony about the costs would have included this.
And did you review the interconnection agreement to see who would be responsible for the interconnection costs?
I have certainly read the interconnection agreement several times. I can't tell you that I ended up with clarity of all the details that are in here.
Okay. And does that, just to conclude my cross-examination, does that surmise all of your changes that have changed your formation of your opinion on this case that were initially reflected in your rebuttal and direct testimonies?
Yes, sir, I think it reasonably does.
Thank you very much. I have nothing further.
Thank you, Mr. Herman. PRC, Utility Division staff.
Thank you, Madam Hearing Examiner. I do have just a handful of questions. Good afternoon, Ms. Souls.
Hello, Mr. Borman.
So if you could turn to page 45 of your testimony, line 17.
Is this my direct testimony you're asking?
I apologize. Yes, it's your direct testimony.
Yes. Page 45.
Yeah.
Give me a moment.
I think it starts on line 16 and then goes on to probably line 18. Do you see that?
Hold on.
Okay.
Yes.
And then actually, I think it starts on line 18. I challenge whether it is appropriate to consider a resource proposed primarily as a capacity resource, not an REA mandated resource in a renewable energy plan filing. Is that right?
That's my testimony, yes.
Okay. So is it your position that a capacity resource cannot be an RPS resource?
It's my position that a capacity resource can certainly provide RECs to be counted towards the RPS requirement, but that it is considered and authorized under somewhat different standards. And those standards, and this is based on my experience in case number 19-00348-UT, those standards have to do with establishing the need for the resource and evaluating the costs of the resource and its other operating characteristics to determine if it is consistent with the most recent integrated resource plan and the best option amongst competing alternatives.
Okay.
Similar to a CCN standard.
I'm sorry, what is CCN?
Certificate of Convenience and Necessity.
Okay, that completes your answer.
I think so.
Okay, so maybe I asked that awkwardly, but are you basically saying that the commission cannot approve a capacity resource as an RPS resource in an RPS plan filing?
I'm saying that it is my understanding that under, what is it, the Rule 572 that applies to the Renewable Energy Act and satisfying it, that those requirements apply to the standard of at least 40% by 2025. But that just because it's a renewable energy resource doesn't mean that the standards that apply to an RPS required resource, in other words, that it's going to be less than the RCT, that is not the standard for a capacity resource. That a capacity resource requires the establishment of need, and that a capacity resource requires the establishment of considering alternatives.
Okay. Well, let's move on. And you've made the point throughout your at least through your cross of other witnesses that you're not an attorney, right?
Is that question, am I an attorney?
You're not an attorney, correct?
I am not an attorney, Mr. Borman.
Okay, but with that understanding, is it your understanding that the commission's new Rule 572 approved by the commission on December 7th, 2022 would have any impact on El Paso's ability to use DG Rex to satisfy its RPS requirement after that new rule becomes effective?
So it's my understanding first that there has been some kind of general agreement that for this proceeding, because it was commenced prior to that rule being adopted, that for this proceeding, the rule is change doesn't apply, that it's essentially irrelevant, that we will conduct this as if that hadn't taken place. It is also my understanding that the legislature is currently considering changing the statutory language to make it clear that DG Recs are to be counted. That there is a bill, SB 326, that would do exactly that. So I think the future has many different possibilities to it at this point.
Okay, that bill hasn't passed yet, has it?
No, the legislature is actively in session. And my understanding is that the Senate Conservation Committee will hear that bill on Tuesday morning.
Okay, but the commission did approve the changes to Rule 572 already, is that correct?
That's what I've been told.
Okay. Those are my questions. Thank you.
Thank you, Mr. Borman. So Ms. Souls, I understand that you're saying that you would have changed your testimony in some respects. Do you think that there would have been a change in your recommendations with respect to whether or not the Carney project is an appropriate project for EP at this juncture?
Regarding the Carney project, I don't think I would have reached a different conclusion.
And do you think you would have reached a different conclusion on the other items that you discussed with Mr. Herman, which would have included the RPS standard and table VM3, the assumptions about community solar in Buena Vista. Even though the testimony might have been revised in some ways to reflect changes in the numbers that were used by EPE's witness, do you think it would have changed the outcome or ultimate conclusion
Yes,
of your
possibly.
testimony?
So as of today, I would agree that El Paso Electric has a plan to satisfy the 20% RPS requirement in 2023. As every week goes by and Buena Vista doesn't start, I find that plan becomes more shaky. So as of today, yes, I would probably have written different testimony if that had been where we started.
Okay. And what about the calculation of the RPS cost rider? You said you don't know whether or not you would have changed your recommend. Is that correct? You don't know whether or not you would have changed your recommendations?
In all honesty, I have not gone back and done additional calculations based on the shift in the testimony and the response to your bench requests. I do know that witness Gonzalez for El Paso Electric did change his testimony to acknowledge that there had been an error in the calculation of the proposed cost rider.
Mm-hmm.
And that had been one of the main thrusts of my testimony.
And then your wish to offer Exhibit 6. And at the time that you initially raised this, EP indicated that it hadn't had an opportunity to review Exhibit 6, which I've only looked at Exhibit 6 relatively superficially. Mr. Wexler, have you had an opportunity to review Exhibit 6 at this point? And what do you have a position on? Does EPE have a position on it?
Yeah, we do. We have had a chance to review it. I will say, I understood the testimony that the colloquy between Mr. Herman and Ms. Souls to be basically, would you have changed anything and why you would have changed anything? And we don't have a problem with that sort of discussion. Obviously, if that testimony went to the actual truth of the matters asserted, meaning the meaning of the LGIA or anything underlying it, that would be different. Because Ms. Souls simply doesn't have the foundation for that. So with that as an explanation, Exhibit 6, MLS 6 is a document that is available on the FERC website. We've checked it and it looks correct. We then, for the limited purposes of showing that this is the document reflecting the LGIA, we don't have a problem with that. But as I said, anything going to substantive testimony, we think is beyond the scope here, and there's no foundation. So no objection to the exhibit.
Ms. Souls, is this is an unexecuted interconnection agreement? What is the purpose for offering this when it's not executed?
So it's my understanding that it was unexecuted when it was filed in November, but that with the passage of 60 days, it becomes the official interconnection agreement. As Mr. Borman sought to point out, I am not an attorney, and that is probably not within my realm of expertise to claim to know that. But I understand this document to be an integral part of the Carne project.
Um, and that's based on,
Based on Mr.
on
Hawkins,
what?
Mr. Hawkins' response to cross-examination back on January 31st.
I would have to look that up, but can you summarize what your recollection is of that?
Mr. Hawkins had filed rebuttal testimony,
Mhm.
and that rebuttal testimony led us to a discussion about the contracts, the purchase power agreement. In particular, I don't believe we looked specifically at the energy storage agreement. And the purchase power agreement references this interconnection agreement, and I had asked Mr. Hawkins about that. And he's the one that had referred to this publicly available document on the FERC website. And I had asked you, therefore, how do we deal with this? And that your direction is why I sought to introduce it as an exhibit when I introduced my testimony.
But we don't know at this point if this agreement is currently in force. You think that it probably, or your understanding is that it would be because 60 days have expired.
Yes, ma'am.
And is that by statute or by the terms of the agreement, or you don't know?
It may be that I understood that from the introductory letter that is part of this exhibit. I'm not sure.
Okay.
Like I said, I'm not an attorney.
Well, I mean, it can be admitted without objection, but its value is very limited given this uncertainty about whether or not it's in fact even in effect or effective in any way. So for whatever it is worth, which may not be much, it can be admitted as Souls Exhibit 6. I still have significant concerns about your Exhibit 1. Based on the examination conducted by Mr. Herman and your responses. I think that Exhibit 1 can be admitted in the form that it currently exists without revision.
Thank you.
And without reference to, to whatever changes you think might have been made. And then I did have a couple of other follow-up questions for you. I guess Mr. Wexler asked you some questions with respect to your interest in this case as an intervener. And I believe your amended motion for intervention indicated that you had become a customer in November.
That's correct.
Okay. And that's your status as a customer is based on the responses to the questions that were tendered by Mr. Wexler.
I am a customer. I am financially responsible for that bill. I could give you the account number. I am a customer.
But your responses to Mr. Wexler were correct.
Yes, ma'am, I was under oath.
Thank you. And your testimony is not that of an expert, is that correct?
I'm offering my testimony as an expert.
As an expert in utility planning?
Okay,
kind
in
of
in the things to which I testified, of course, it's my understanding that in a civil procedure like this, it is up to you as the hearing examiner to value that at whatever it is worth.
But I didn't see in your testimony that you were specifically describing any expertise per se in utility planning or calculation of budgets or
Madam Hearing
resource
Examiner,
planning.
I will claim that experience. I will claim that knowledge. I will claim the education as an engineer and as a business person. Absolutely, I claim that.
But your experience was relative to areas other than utility development?
Well, since I've been working in this arena since 2014, that is certainly some amount of experience and knowledge that perhaps has value to you.
Okay. All right. Thank you, Ms. Souls. I understand that do you have, I guess, any redirect testimony in response to the cross-examination by Mr. Wexler or Mr. Herman or my questions?
No, ma'am, I think I'm quite done.
Thank you, Ms. Souls. And I believe you do have two other witnesses today.
Yes, I'd like to bring forward Corey Aspel. Hopefully he's in the waiting room.
I do not see him in the waiting room, and I'm sorry if I just admitted Mr. Gedko and Mr. Downs, and I don't know how long they were in the waiting room. Mr. Gedko, I apologize if you were in the waiting room for very long. And Mr. Downs.
I appreciate it. I was watching on YouTube, and so thank you for finding me.
All right, Ms. Aspel is in the waiting room, and I am admitting.
Excellent.
Mr. Aspel. Ms. Gonzalez, can you swear in Mr. Aspel?
You bet. Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Hello, Mr. Aspel.
Hello, Miss Souls.
Would you please state your full name and spell it for the record?
Yes, Corey, Corey, Asbill, Asbill.
And what is your current profession?
I am co-owner of Oregon Mountain Solar and Electric in Las Cruces, New Mexico.
And do you have before you what has been identified as Souls Exhibit 2, the direct testimony of Corey Aspel?
I do have that.
And do you recognize this as your direct testimony in this case?
Yes, ma'am.
Was it drafted by you or under your direct supervision?
Yes, it was.
Do you have any corrections to make?
There are some corrections which I believe have been submitted that we can go through now.
Yes, please.
There is the elimination of a duplicate, largely duplicate information, and that is marked as Exhibit CA-2, page 4 of 9 in the original. That then, of course, alters the page numbering, which may make things confusing.
Would you please reference the Bates numbering that's in the bottom left-hand
Of course.
corner?
Of course I will. Let me get there again. The original would have been Souls Exhibit 217 of 25. Eliminate that page. Okay.
Are there any other corrections?
There are. The rest are transcription errors, my fault. So on page, in this case, it would be 19, I believe. Pardon me one second. As I mentioned, there will be some confusion with the changes. So I'll refer to the original number in the bottom left corner. So on page Souls Exhibit 219 of 25, on the line marked non-summer demand charge, DC, I'd like to change the dollar amount from $13.23 to $13.93. Then the second correction on this page was the duplicate use of a variable, and that is on line federal tax credit rate. Originally it was FR. I'd like to change that to FTR. Okay.
Okay.
Then moving on to original page numbering, Souls Exhibit 220 of 25. The changes that I'm about to go through will translate to the next, the following 3 pages. The page we're on, and then 21 of 25 and 22 of 25 as well. These were transcription errors in which I was extracting the equations for clarity's sake, putting them in here, and made a couple of errors that I'd like to correct. And like I said, they'll translate through all of the next 3 pages. The first one is on federal tax credit FT line. We will change NC times FC to read NC times FTR.
This is on page 9.
That is on original numbering 20 of 25.
Oh, 20.
That's right, 20 of 25. And again, translate that to the next 2 pages as well. It's exactly the same thing. The second correction on this page is on the line below that EU ERF rate charge UC. I'd like to change the plus RC in that equation to read plus FC, and then the times ER at the end of that equation to read times UR. Again, translate that to pages 19, 20, and 21. There are 2 changes on franchise rate LT line. I'd like to add the word charge after the word rate. Franchise rate charge LT. That's the first change, which translates to the 3 pages. And then after plus RC and before plus FT, inject plus FC. Plus RC plus FC plus FT. Again, translate to the following 2 pages. And then the final change is on the taxes line. Same as above. Enter plus C between RC and FT. So it will read plus RC plus FC plus FT. And I apologize for these oversights. This was done near the end of the submission and after a very long December.
So when you actually perform the calculations, you used the formulas that you have now described as opposed to the formulas that were originally contained in your testimony?
Yes, ma'am. These were supplemental to the calculations. These changes have no effect on the results of the calculations. These were simply transcription errors as I extracted information from the calculation and assigned variable names to them and inserted them here. So yes, ma'am.
Thank you. Go ahead, Miss Souls.
Very well. And Mr. Aspel, with those corrections, if you were asked the same questions today, would your answers be the same?
They would.
Is your testimony is presented here true and correct to the best of your knowledge and belief?
Yes, ma'am.
Madam Hearing Examiner, with that, I move admission of Souls Exhibit 2.
Any objection? Hearing none, Souls Exhibit 2 is admitted. Do you wish to pass the witness, Ms. Souls?
Yes, ma'am. I hereby offer Mr. Aspel for cross-examination.
Starting with El Paso Electric, I see Ms. Olson. Will you be cross-examining Mr. Aspel?
Thank you, Madam Hearing Examiner, and good afternoon, Mr. Aspel. The company has no cross-examination for this witness.
Thank you, Ms. Olson.
Office of the Attorney General.
We have no questions for Mr. Aspel. Thank you.
Thank you.
City of Las Cruces.
Good afternoon, Mr. Asbill. We have no questions for Mr. Asbill.
Thank you, ma'am.
Mr. Downs.
I have no questions, Madam Hearing Examiner.
Okay. Doña Ana County, Mr. Herman.
Yes, Madam Examiner, I have a brief line of questioning.
Go ahead, Mr. Herman.
Good afternoon, Mr. Asbill. My name is Keith Herman. I am outside counsel for Doña Ana County.
Hello, Mr. Herman.
We have not had a chance to meet yet, but this is your first time appearing before the PRC, correct?
Yes, and I can feel it in my stomach. Yes, sir.
Well, welcome. I hope it's a good feeling in your stomach. But I just wanted to ask you what information you reviewed in preparing your testimony today.
The information reviewed to prepare this testimony on a specific level in terms of the calculations of the two commercial buyers in comparison was the use of the readily available tools such as the PV Watts in-rail application to determine system performance, solar energy system performance over time. And then
can I pause you right there? You said
yes.
NREL application. Could you spell out that acronym?
Yes. You're referring to NREL or PV Watts, which is the application?
Both. Just could you explain both?
Of course.
Are in the difference?
Yes, the National Renewable Energy Laboratory and the development of the PV Watts application online, which allows you to enter solar energy system information. What type of module are you using? How many are there? What direction are they looking? Things like that. And it will use weather information in the location to determine the output of the system in that location, given the characteristics. PV space WATTS.
And is that all you relied on to prepare your testimony?
The calculations then are relatively straightforward in terms of determining what the financial impact is on the customer's electric bill. In the case, especially for the alternative rate, number 3, El Paso Electric, for each kilowatt hour produced and consumed on site, it offsets the retail cost of that kilowatt hour. And so that, along with the impact on the additional riders in the bill, that is what the Exhibit 2 is all about, is the descriptions of how we calculated the impact of consumed solar energy on site.
And did you rely on anything else to draft your testimony, or is that complete?
I relied also on something a little less tangible, I guess you'd say, and that is my experience with customers responding to proposals in different utility, under different utility rates. So obviously, I compared customer interests and responsiveness and purchasing, for example, of the residential solar energy systems. My experience within the alternative, small commercial alternative rate 3, and the conversations that I've had with those individuals. And then in the general services rate number 3 as well. And then in contrast, the conversations I've had with commercial and potential commercial DG purchasers under P&M, especially P&M's rate 2A, for example, and compared the relative ease at which someone could transition to the ownership of a DG system in those comparisons. Is that clear?
Yeah, let me follow up on that. Just with these customer interactions, are you referring specifically to customer interactions that you've had in your role as I'm sorry, I'm not finding your title. In your role with Oregon Mountain Solar?
Yes.
Oregon Mountain Solar and Electric?
Yes, that is one of the points of reference that I use, and that is the most recent for the past 5 years. Prior to that, I was the sales manager for a regional sales manager for Positive Energy Solar, which had a branch in Las Cruces as well. And so I've had many interactions with potential commercial clients in multiple utilities.
So about those utilities, we're talking about P&M, we're talking about El Paso Electric, any other utilities, any other markets?
Of course, all the ones in the southern part of the state, with the exception of Excel and SPS on the eastern part of the state. So Columbus Electric, Sierra Electric, T Electric, Otero County.
Sorry, you cut in and out. Can you repeat?
Yes, ma'am. So
I believe
where did you
put
lose?
out after Sierra Electric?
That may have very well been the last one. Sierra, Otero Electric Co-op.
Okay.
Otero County Electric Co-op.
So are you familiar with some legislation that was mentioned earlier, SB 326?
Yes, sir.
Could you summarize what the changes are in SB 326?
I can try.
If it helps, I have uploaded this as Doña County Exhibit 1.
I have it in front of me. It's an interesting question in that, in my understanding, the utilities, the IOUs, all treated this subject differently, therefore the clarification came about. El Paso Electric, in my understanding, had been laying claim to the RECs produced by distributed generation systems in their territory up until the point of the rules clarification. And that's always been my understanding. With the clarification came this idea of, apparently, again, I'm not an expert on this and it is quite new, that solar energy RECs consumed on site during the billing cycle could not then be claimed by the utility unless the energy produced by the systems was in excess of consumption, on-site consumption in the billing cycle and purchased at the avoided cost rate, that those RECs could be claimed, but the RECs described prior could not. That's what I believe the clarification to be. SB 326 is an attempt, I believe, to then rectify that such that the utilities can claim on-site consumed energy produced by DG. That's my understanding.
Thank you for that. If SB 326 in its current form is passed, would your testimony change at all?
No, it would strengthen. It wouldn't change.
I have no further questions. Madam Hearing Examiner, I have uploaded SB 326 as Doña Ana County Exhibit 1. However, I believe this might be more appropriate for administrative notice because this is just a current version of the bill. It can change. There would be additional fiscal impact reports, and I don't know if anything will be done on it by the time briefing is done, but just for the sake that myself or any of the other parties might like to reference the current proceedings in briefing, I would request that we take administrative notice.
Any objection or comment on that, Ms. Olson?
Madam Hearing Examiner, EPE objects to use of this as an exhibit in this proceeding. My understanding is this is just a bill that's been introduced in the legislature. There's no foundation for the substance of the bill. There's no relevance to this case or impact on the issues that are pending before this case, and it's unclear what the fate of this bill will ultimately be. So it has no persuasive value or effect or relevance to this proceeding.
That was why I requested administrative notice, just for sake of whatever argument we may want to raise. And Mr. Asbill has already testified to some impact on EPE rate 3 about it.
I think administrative notice can be taken of SB 326. And I think, as you point out, Ms. Olson, certainly any comment on it is, subject to whatever deference it may deserve, which may be a lot, maybe very little. So it's subject to, I think, argument and briefing, if it is even discussed. All right. So, Mr. Aspel, just a couple of questions. So the focus of your testimony is rate 3 and the impact on potential customers who might be interested in distributed solar, distributed generation solar.
Yes, ma'am, that's correct.
And so really, as someone who sells solar systems, right? Is that correct?
That is correct.
So you believe that the proposal that you have here for revising rate 3 would improve participation in the purchase of distributed generation solar systems by small customers?
Absolutely, wholeheartedly. Yes.
Okay. All right. Thank you very much, Mr. Aspel. I don't have any other questions. Ms. Souls, do you have any questions for Mr. Aspel? Redirect.
No, I do not. Thank you.
Thank you, everyone.
Thank you, Mr. Aspel. You are released.
Thank you.
You're welcome. And Ms. Souls, you have another witness.
I do have one more witness, and that would be Philip Simpson.
And I am admitting him right now from the waiting room. Mr. Simpson, do you have video available? And I believe you're also muted. Mr. Simpson, do you have video available?
Your Honor, I don't know if you can hear me.
Yes, I do hear you now.
I trying to switch between YouTube and Zoom. Okay, there.
I think you probably just need to close out of Zoom.
Yes, I have closed.
Out of YouTube.
I mean, out of YouTube. Out of YouTube. Sorry.
Yes, I've closed that now, but it's telling me I cannot start video. I apologize. I'm getting repeated, cannot start video. With your permission, I think I will leave and retry to connect.
That's fine. Why don't we go ahead and do that?
Okay, thank you.
Mm-mm.
Madam Hearing Examiner, can you hear me now?
I do. Still no video.
Still no video. I apologize. I'm getting the same message. Might I suggest we take a quick break while I try to restart my computer and get back in?
Yeah, sure. Why don't we take a 5-minute break?
Thank you.
So we'll go off the record for 5 minutes.
Thank you.
All right, if our court reporter is ready, we'll go back on the record.
There I am. Thank you.
Thank you, Ms. Gonzalez. So we are going back on the record in the matter of 22-00093. And we have the next witness available for Mary Lee Souls. So why don't we start by swearing in Mr. Simpson?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you.
Hello, Mr. Simpson. Would you state your full name for the record and spell it, please?
Yes, Philip B. Simpson. That's Philip. B as in Baker. Simpson.
And what is your current profession?
My current profession is mostly retired, although I do have a small business now in order to do work for certain customers.
And do you have before you what has been identified as Souls Exhibit 3?
I am pulling it up now because I had to close everything when I restarted, but I will have it available in just a moment. That's my direct testimony, I assume.
I hope so, yes.
Yes, I've got it here.
And do you recognize this as your direct testimony in this case?
Yes, I do.
Was it drafted by you or under your supervision?
Yes, it was.
And do you have any corrections to make to your testimony?
I do not.
If you were asked the same questions today, would your answers be the same?
My answers would be the same. My answers would have grown and I would have added text based on things that have happened since I filed this testimony. For example, became aware of the rule changing in 20-00158 regarding DG Rex, but that rule change does not substantially impact my testimony.
And is the testimony presented here true and correct to the best of your knowledge and belief?
Yes, it is.
Madam Hearing Examiner, with that, I move Souls Exhibit 3, the direct testimony of Philip B. Simpson.
Is there any objection? Hearing none, Exhibit 3 is admitted.
Thank you. And I offer the witness for cross-examination.
Thank you. El Paso Electric, Ms. Olson.
Thank you, Madam Hearing Examiner. Good afternoon, Mr. Simpson. Nice to see you again.
Good to see you too, Ms. Olson.
I just have very brief cross-examination. You mentioned the recent rule change in case number 120-00158-UT. Is that correct?
That's correct.
And what's the rule change that you're referring to?
To be brief, the rule change in my mind means that it's becomes very difficult for El Paso Electric to claim DG Rex from solar customers unless El Paso Electric enters into a contract with that customer to pay for those RECs.
Okay, and just to back up a little bit, what's the rule that you're referring to?
I believe it's 17.9.572.10C3.
Okay, and I realize you're not a lawyer, and so if you don't know, feel free to just say I don't know, but are you aware of whether or not that rule has actually taken effect yet?
You know, I cannot speak to that with authority, so I will just say I'm not sure.
Okay, and assuming that that rule has not gone into effect yet, the rule is not yet, or that rule change is not yet effective, is it your position that it is applicable to the case that's pending before the commission, this case?
Well, my understanding is that this case would be treated under the rules that your application was filed under, that your plan was filed under, so that this new rule would not be effective in this
Excuse me.
case. But again, I'm not a lawyer, so that's just my understanding.
Sure. Okay, thank you. I appreciate that clarification. I have no other questions.
Thank you.
Okay. City of Los, I'm sorry, Office of the Attorney General, Mr. Gedko.
Yes, I do not have any questions for Mr. Simpson. Thank you.
City of Las Cruces, Ms. Stevens.
Good afternoon, Mr. Simpson. I do not have any questions for Mr. Simpson.
Thank you.
Mr. Downs.
I have no questions for Mr. Simpson, Madam Hearing Examiner.
Doña Ana County, Mr. Herman.
My questions have already been covered by Ms. Olson, but it is good to see you, Mr. Simpson.
Thank you, Mr. Herman. You too.
And finally, PRC staff.
Staff has no
Foreman.
questions.
I did have one question, Mr. Simpson. In the previous cases that you mentioned participating in or testifying in, do you know whether or not you were recognized as an expert for your testimony in those cases?
I am trying to recall. I believe that in case number 19-00348, I claimed to be an expert. And I believe that that was not challenged, if I recall correctly.
Okay. All right. And in this case, is your are you presenting your testimony as an expert or as a lay witness?
As an expert.
All right. I don't believe I have any other questions for you. Thank you, Mr. Simpson. Any
Thank you, Mr.
redirect,
Simpson.
Miss?
No, ma'am, I have no redirect.
Okay. Well, I think that will conclude your testimony, Mr. Simpson, so you can be released as a witness, and we appreciate your efforts to participate. Thank you.
Yes, and thank you for your patience. I appreciate it.
So we'll turn, I believe at this point, to staff witnesses. PRC staff witnesses.
Do we have Mr. Tupler on here? I don't see him.
No, and I don't see him in the waiting room, so I don't know if you want to let him know,
Yeah,
or
we
maybe he's in the
tried-
process.
tried texting him, but
Well, I'm watching the waiting room, so as soon as he appears, I'll let him in. There we go.
got him.
Mhm.
Okay.
Mr. Tupler, do you want to go ahead and turn on your video and audio?
There we go. That little buffer between YouTube and live.
Thank you. Ms. Gonzalez, can you swear in Mr. Tupler?
Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Good afternoon, Madam Hearing Examiner. I'm going to be doing the questions from now. And please state your name for the record.
My name is Mark Tupler. It's spelled
And by who-
M-A-R-C-T-U-P-L-E-R.
And by whom are you employed and in what capacity?
I am a senior economist with the New Mexico Public Regulation Commission Utility Division.
And as part of your duties in that position, did you review the amended application that El Paso Electric filed in this case for approval of its renewable energy plan? And did you review the testimony that was filed?
Yes, I did.
And based upon your review, did you prepare testimony regarding that application?
I did, yes.
And do you have access to that document marked Staff Exhibit 1?
I do.
And would you identify that?
It is my prepared direct testimony dated January 9, 2023.
Okay. And was that prepared by you or under your supervision?
It was prepared by me.
And do you have any changes or corrections to that testimony today?
No, I believe it stands on its own.
Okay. If I asked you the same questions in the testimony that are set forth in that exhibit, would your answers be the same?
Yes, they would.
And are these answers true and correct to the best of your knowledge?
Yes, they are.
And do you adopt Staff Exhibit 1 as your sworn testimony in this matter?
I do.
And Madam Hearing Examiner, do you want us to go through the Commission Exhibit 3 now, or?
No.
We admit them both together?
No, we can wait till, that's Mr. I'm sorry. Yes, actually, why don't you go ahead with Exhibit 3?
Okay. And Mr. Tepler, do you have access to Commission Exhibit 3?
I believe I do. Let me make sure I'm there. I do. Yes, I do.
Okay. Would you please identify that document?
It is my prepared response to the bench request. I don't see the date, but I think it speaks for itself.
Okay, if you scroll down a little bit, I think you'll see the date. Page 1 of 6? No?
Yeah, bear with me. Let me get to that document. I've got quite a few documents open, as I think we all do at one point or another. Commission Exhibit 3.
Yes.
Okay, it's coming up here, dated January 30, 2023.
Thank you. And was Commission Exhibit 3 prepared by you or under your supervision?
It was prepared by me.
And do you have any changes or corrections to that testimony?
I do.
And would you describe it?
So on Bates page 3, there is, let me get there. There is a number at page 20. Line 20. There is a number there represented as 11.637. That number should be 11,637.
Okay, thank you. Any other corrections?
Those are my only corrections.
And if we asked you the same questions today that are set forth along with your corrections, would they be the same?
Yes.
And are the answers true and correct to the best of your knowledge?
Yes, they are.
At this time, Madam Hearing Examiner, staff requests that Staff Exhibit 1 and Commission Exhibit 3 be admitted, or I guess we're having admission subject to affirmation.
Right. So is there any objection to either Staff Exhibit 1 or Commission Exhibit 3? Hearing none, those are both admitted.
Okay, and at this time, we tender Mr. Tupler for cross-examination.
El Paso Electric, Miss Olson.
Governor, good afternoon, Mr. Tupler. We have no cross-examination for you today.
Office of the Attorney General, Mr. Gedko.
Yes, good afternoon, Mr. Tupler. I do not have any questions for you either. Thank you.
City of Las Cruces, Ms. Stevens.
Good afternoon, Mr. Tupler. I do have some questions. How are you? It's been a while.
Yes. Hi, Miss Stevens. Good to see you again.
I want to ask you a question, starting where you made that correction on Commission Exhibit number 3. I have too many things open right here. Let's see, close my Souls exhibits. And, can you tell that we're on the bottom paragraph of page 3 of 6 of Commission Exhibit 3, carrying over onto the top lines of the other numbers. Can you tell me how you calculated these changed numbers in DG Rex?
So you're asking about the calculations?
Yes, I'm asking how you calculated these changed DG Rec allocations.
So if I remember correctly, these numbers are taken strictly from the updated El Paso Electric Exhibit VM3, if I'm not mistaken. Actually, it's the VM3 table.
The VM3 with 3 Roman numerals, is that what you're referring to, or something else? There are a lot of VM tables. I'm just trying to figure out which one you went to.
Right. So let me get to that table and I can describe it further. I do have it open somewhere in here, I know.
Gotcha.
Okay, so how I'm seeing it described is table VM3.
Of which EPE exhibit are you looking at? That might help.
Well, my records show here that it was updated on January 27th, 2023. So I'm not exactly certain where in the record this is included.
January 20. Well, let me ask you another question then, since it's going to be, there are a lot of exhibits out there. Did you do anything to verify the numbers that you looked at when you picked those numbers out of one of the versions of VM3?
Well, I take the numbers on their face in the exhibit or in the table. I believe my math is correct. So I would say that it's as verified as I can.
And you didn't go back to any other documents or commission records to see what the breakdown of DG Rex is?
I think what I did was relied on some of the previous and comparable tables or the previous versions of this table to make sure that the amounts were accurate and that the breakout in the new updated table matched.
And when you say matched, you just mean that the two pieces that they broke it down totaled the original number?
Yes.
Okay. And you
validation, basically.
So did you do anything to verify what they were separating out or why it was separated out and compare it to historical numbers?
Well, I would tell you, I stared at these tables for a very long time. I can't say that I went back to prior cases or anything along that line to establish or verify those numbers. I took them on their face.
Okay, let's go. Let me close that one so we can not have too many documents open because I'm going to get lost.
Right.
And now I'll ask you, if you would look at what was admitted this morning as CLC Exhibit 4, it was previously back before the other hearing labeled as CLC Exhibit 5. It's the case number 19-00349-UT final order. Do you have that?
I don't have it available right in front of me, but I'm in the Dropbox, so I should be able to pull it up.
Great.
If you could give me that exhibit number again, I'll find it.
Yes. And I'm sorry about the noise here. CLC Exhibit 4.
CLC Exhibit 4. Okay, I see it. Yes.
Okay.
I've got it open.
Okay. And this, do you recognize this as the final order in case number 19-00349 UT?
Yes.
Have you read that order?
I don't believe that I have.
Do you consider it important as a staff expert to be familiar with the commission's orders directed to the utility about which you are testifying in a given case?
Absolutely.
Can I direct you to paragraph 33 on page 10 of 14 of that document?
Okay, I'm there.
Okay. Were you present on January 30th when Mr. Novello was testifying?
I was.
Okay, well then maybe if you would read this paragraph 33, maybe you've seen it then before.
Okay, so I see paragraph 33 on page 10 stating that the commission further finds that EPE should be ordered to provide in its next application for approval of any resource acquisition, whether by CNN or long-term purchase power agreement, a comprehensive plan showing how EPE will comply with the renewable energy and zero carbon energy requirements of New Mexico law.
Do you consider EPE's application in the present case for approval of the 130 megawatt solar PV, 65 megawatt battery storage facility, Kearney facility, to be a resource acquisition?
I would say so, yes.
Do you believe that EPE has provided a comprehensive plan showing how it will comply with the renewable energy and zero carbon energy requirements of New Mexico law in this case?
I think the operative word here is comprehensive. I would say that it's a reasonably comprehensive plan, yes.
And what makes it a reasonably comprehensive plan in your mind?
I think they are in the best position to provide the details for what their plan consists of. My review of the plan seems reasonable considering the resources available.
And very generally regarding your actual direct testimony, it seems to focus on the specific requirements of Rule 572, is that correct?
Yes.
And that basically limits the company's presentation to requirements for the so-called plan year and the next plan year, is that right?
Yes.
And in this case, the plan year is 2023 and the next plan year is 2024, is that right?
Yes.
And do you think that a comprehensive plan showing how EPA will comply with the renewable energy and zero carbon energy requirements of New Mexico law should stop in 2 years?
Well, I think because of the way the filing requirement is to provide a current year plan plus a next year informational plan, it seems reasonable to me.
Do you understand that the commission may impose requirements on EPE or any other utility in a case that are in addition to what a generic rule requires?
Yes, I'd say so, yes.
And is it the staff's position, your position, that this paragraph 33 was not intended to impose a specific requirement on El Paso Electric above and beyond Rule 572?
Let me look at the paragraph again. I hope I'm not missing something.
And I'm sorry, you're looking at what page?
It is page 10, I believe, paragraph 33 of CLC Exhibit 3, I think.
4.
4, I'm sorry. So I'm a little unsure of any time requirement required in something that is considered comprehensive. I'm comfortable enough, though, with the plan presented that it's comprehensive in its requirement for 2023 and its information for 2024.
Okay, let's move on back to, let's close this one. Clear the decks. And get back to your direct testimony. On page 8 of 33 of the Bates stamping.
Okay, let me get back to my testimony here. Okay, please give me the page again.
8 of 33, which is actually page 6 of your testimony.
Okay, thank you. I'm on page 6.
Okay, and I'm on that first or only full question and answer beginning on the page beginning on line 5. You with me?
Yes.
And I'm looking about, you testify that Victor Martinez in his exhibit VM1 provides calculations that reduce total retail sales to New Mexico customers due to projected purchases of renewable energy, i.e. weather, projected energy efficiency, distributed generation, and the NMSU solar project. And I'm wondering where in Mr. Martinez's exhibit VM1 did you find any specific figures for weather-related adjustments? If you did.
I don't believe the adjustment was weather-based. If I'm not mistaken, it had something to do with a specific solar project, maybe with NMSU. I don't recall.
No.
I don't recall any weather-related adjustments, though.
Well, your testimony refers to weather, projected energy efficiency, distributed generation, and the NMSU solar project.
That might have been a generic example there of what the adjustments to the total retail sales could include.
And so that would relate to the company's more general load forecast. Is that right?
Well, I would say it's not even specific to El Paso Electric. It's my interpretation of the adjustments that the IOUs are required to make to the retail sales is how I intended it to be projected.
Did you review EPE's energy forecast for New Mexico before filing your testimony?
I'm certain I did.
Did you review the inputs that relating to weather adjustments, energy efficient adjustments, distributed generations?
In the normal course of my as I put the testimony together, I certainly would have looked at each of the components.
Which document were you looking at?
So I mentioned in my testimony that it's Exhibit VM1.
Right.
That's what I would have relied on.
Okay, let's look at Exhibit VM1. I believe that's EPE Exhibit 3. Is that in EPE Exhibit 3? Mr. Martinez's direct
Let
testimony?
me find it and I can speak a little better towards it. Help me understand that exhibit again, please.
I think that you're referring to VM1 as the program plan, which was attached to Mr. Martinez's direct testimony, which is EPE Exhibit 3. Do you have access to that?
EPE Exhibit 3, I do have it here, yes.
And
It's on page 436 of 821. Or I'm sorry, 437.
Okay, my computer's trying to get there.
oh, wait a second, Madam Hearing Examiner, I'm looking at a version of EPE Exhibit 3 that has 309 pages. Oh, you're looking at the Bates number. I understand. Yeah.
Could you state the page again, please?
Well, if I have the correct Exhibit 3, which is a direct testimony of Mr.
Right.
Martinez, the Bates numbering is page 437 of 821, which actually on the Adobe, it's showing page 47 of 309.
Okay.
I think I separated. I think if you look at the entire application package, that's what that Bates number refers to. But if you look only at Exhibit 3, the Bates number would be page 47 of 309.
So, Mr. Topler, are you with, I think the hearing examiner and I are in the same place now. Are you? That's the important, you're the important.
Right, I'm getting there.
But page 47
okay,
showing on the numbering that's up above on the menu bar of Adobe Acrobat, not the numbering that's on the pages of the exhibit. The numbering on the pages of the exhibit would be 437 of 821.
I may not have this correct exhibit. I don't see on PDF page 47, I see a table of contents in the direct testimony of Victor Martinez.
Okay. Well, this is what I'm looking at.
Yeah.
As exhibit VM1.
Right.
Which you can see up here on the menu line of Adobe is page 46, page 47 of 309, but on the Bates stamping, it's showing page 437 of 821.
And the Bates stamps came from the original
full
filed as
application.
one piece, right?
Right, the full application.
I'm sorry, I didn't quite understand that.
I don't know.
And the Bates stamps came from the original, and I didn't hear it.
From the original application package.
Ms. Stevens, if it's helpful, I believe that I am at the proper exhibit now.
Great. Okay, good. So let me ask you then what you reviewed in terms of being the company's New Mexico retail energy projections.
So I see a table 1 in that exhibit. It's got 5 lines to it. The first line is the forecasted kilowatt sales. The following line number 2 is the adjustment. And line 3, I consider the forecasted retail sales.
Okay,
And that number should match to my testimony.
right. And my question to you was, testimony described the components
I'm
of.
sorry, please repeat, Ms. Stevens, you cut out.
Oh, my question before we got lost in cyberspace was whether you refer to having reviewed in the course of your work EPE's forecasts of jurisdictional sales, and that's the 1,743,747,577 kilowatt hours on line 1, correct?
Yes, ma'am.
And did you, in any context, have you done anything to review what went into that number?
I don't believe I know or have seen anything that makes up that number other than how it's projected in the application.
So this is the number you just took EP's number.
Yes.
All right. And going back to your testimony, it had the parenthetical references to weather, energy efficiency, and distributed generation. Did you make any?
I'm sorry, please repeat that. And going back to your testimony.
Your own testimony that parenthetically referred to weather, energy efficiency, and distributed generation adjustments. Did you independently review any of those possible components of the forecasted New Mexico jurisdictional sales?
I don't believe there were any that I was able to notice. So if I didn't notice them, I didn't dive into it.
And regarding and I see here you had mentioned earlier, and I was asking you, there's the New Mexico State University Solar Project adjustment. Are you familiar with the order in the case that approved that project?
I can say that I'm generally aware of it, but I can't validate anything beyond the number that I used in my testimony. I'm not familiar enough with the case.
Okay. So you don't know specifically whether the commission in that case authorized this sort of adjustment. You're just taking it at its word. Right?
I would say that's accurate. Yes, I
Okay.
am not aware of any conditions on that adjustment.
Let's close Mr. Martinez's testimony and get back to yours. And now I'm on page page 9 of 33, your testimony.
Okay, page 9, I'm there.
And I'm on lines 2 to 4, where you talk about you testify as well, EPE maintains that the reallocation of Macho Springs Energy and RECs to New Mexico customers is needed to have sufficient RECs to meet 20% RPS in the 2023 plan year. See that sentence?
I don't see it right now. For some reason, I'm not aligned
You're not in the
with
same
where you're
place
reading
as I?
from.
Okay, I'm in your direct exhibit 1. Could you possibly have shifted to your exhibit, commission exhibit 3, lines starting in towards the end of line 2 through line 4?
May I ask for the page number again, just to make sure I can double check it?
It's 9 of 33 in the Bates stamps, or 7 as your own number before it got Bates stamped.
Okay, I'm there now. Yes.
Okay. So if you would read that sentence that begins towards the end of line 2, and finishes near the end of line 4, just to yourself.
Okay, I've read it.
Okay, and I know you've been attending on Zoom a lot of this hearing, Mr. Tepler. Is it still your position that EPE is insisting that the reallocation of Macho Springs is needed to have sufficient recs to meet 20% RPS in 2023?
For 2023, I'm uncertain if the resources are going to be available to meet the 20% RPS. Macho Springs, I'm not certain is eligible for meeting that RPS requirement, but it would be helpful towards it, certainly.
When you say you're not sure about the resources being available, are you referring to the Buena Vista and Hecate projects?
Correct.
Going down on the same page, let's make it life easier for ourselves. Lines 13 through 16.
I see it.
Yeah, and here you testify that EPE projects a total revenue requirement of approximately 14.9% to meet the RPS in 2023. Are you referring to the revenue requirement for the RPS cost rider?
So I see a number there that is approximately $14.9 million.
Mm-hmm. Is it your understanding that those are that so-called revenue requirement, your term, is the requested revenue requirement through the RPS cost rider exclusively?
That's the framing in my mind, yes.
And are you familiar with the bench request response or the record as a whole as to how much the Carney project would add on an annual basis to EPE's RPS compliance costs?
Well, I'm familiar with the Carney project's costs, yes.
And is that number, at least in the first year, approximately $20.5 million?
That sounds about right.
And does staff, I don't see in your testimony or Mr. Otaro's testimony anything addressing any concerns addressing that large increase in revenues to be collected from New Mexico customers. Has staff taken any position on that?
I don't believe that was in my testimony. So I don't know if I'm in the position to speak towards that.
Okay. But you didn't choose to speak towards that.
I'm sorry?
You did not choose to speak towards that in your testimony?
No.
And is that a consequence of your focusing on the plan year of 2023 and the next plan year 2024, or is there another reason why you didn't focus on that? Address that.
I think it might be because of the focus on the 2023 and 2024 forecast.
Okay. Would you turn to Living Dangerously here, page 10 of 33, which is just the next page?
Okay, I'm there.
Okay. And I'm looking at lines 11 through 19 under the heading New Procurement.
I see it.
With, is it staff's opinion? I don't want to, is it your opinion? I assume you speak for staff that El Paso Electric has a need for 120 megawatts of additional capacity to serve New Mexico customers?
I would say so, yes.
What is the basis of that opinion?
If I'm not mistaken, somewhere in the record is a forecast of the capacity required. Maybe it's termed differently, but that's what I'm remembering in my mind, that outlines their required capacity needs.
And are you referring, if you can, scrape through your mind and try to think what you're referring to, I'm wondering whether you're talking about some sort of a loads and resources type table, or the RFP for resources in this case.
So I need to hear that question again. I'm a little unsure what I'm answering.
I'm the two sources that pop into my head as possibilities would be something in the format of a loads and resources table over years, or because it's been discussed in other people's testimony and cross-examination, the RFP, request for proposals, that produce the bids in this case. And I was just wondering whether that might refresh your memory as to where you saw that, you think you saw that 121 megawatt capacity justified.
Well, that does make sense to me, that the RFP would have explained what the procurement is intended for. So if I can place it there, it makes sense to me.
I'm trying to ask you, though, to really tell me what you relied on, not what you might be able to place it towards.
Okay. I guess I took a different approach on this procurement, because I see the procurement as critical to meeting the RPS hurdle.
And have you looked at the various, oops, I think I've lost. There you go. Okay, sorry, I lost you there. I got Ms. Regensburg. When you say it's critical to meeting the RPS requirement, can you tell me how much additional energy EPE, assuming that Buena Vista and Hecate are approved and constructed, which is, I think, the assumption that underlies all of this, can you tell me how much energy EPE, renewable energy EPE, needs to meet the 40% requirement in 2025?
Well, for that information, I would have relied on the updated VM3 table, I believe, that outlines each of the year's requirements. I would have relied solely on that.
And I guess when you say updated, when you wrote your testimony, you were relying on the company's original testimony, correct?
Yes, ma'am.
And now it's been revised several times. Would you prefer to look at the one of the more recent ones, or the one that you looked at when you were filing your testimony?
Well, just to keep things consistent, I think it's wise to use the data or the table that I utilized in my original direct testimony.
Okay, then we're going to have to go back to EPE Exhibit 3, Mr. Martinez's direct testimony, which I had optimistically closed. So give me a second here.
Is that Exhibit VM3?
This is EPE Exhibit 3.
Right, but Exhibit
to
VM3 within that?
No, it would be a table VM3. And I'll ask, Oh, maybe it is the exhibit VM3.
I think so.
Okay. No, I don't think it's this one, Mr. I don't think it's exhibit VM3, which is page 453 of 821, because this only goes to 2024. So I think it's probably a table VM3. In Mr. Martinez's testimony. There should be a law, Madam Hearing Examiner, there should be a law on tables versus exhibit.
Really? There's a table VM3?
Yeah, the colored tables, I think if we go cruising through here looking for the colored.
It's on page 428 of 821.
Thank you.
Mr. Martinez's testimony.
Oh, I see this.
So thank you, Ms. Regensberg. So Mr. Tupler, are you with me now? With us?
I
now?
am. I believe I am. I see table VM3 in front of me.
And this is what you relied on when you were writing your testimony, correct?
Yes, ma'am.
So under this view, which has changed several times, El Paso Electric with the Carne project partially in service in 2025 would be at an RPS of nearly 50%. Is that correct?
That's what the table reflects, yes.
And then the following year, when you have a full 398,343 megawatt hours from Carne, it would jump up to 54.5%. Is that right?
That's correct.
So is it your position that a project as large as Carne is needed to hit 40% RPS?
Can I hear the question again, please?
Yeah. Is it your opinion that a project as large as Carne is needed, and I think that was your term in your testimony, to meet a 40% RPS requirement?
Well, I would say that considering the other circumstances, and we can get into those as well, I believe that it will be needed.
When?
ASAP, in my opinion.
Pardon?
However, as soon as
ASAP.
possible, in my opinion, in order to meet the hurdles that are in front of them.
So are you assuming that Buena Vista or Hecate will not come online into commercial operation in a timely manner based on the new assumptions?
Well, considering it's still a pending case, I have to make some assumptions with it and without it, because I don't know how that will be resolved.
I'm so sorry about the background noise. I just can't do anything about it here. And was your testimony premised on assumptions that there was a large degree of uncertainty on Buena Vista and Hecate?
I would say just a normal amount of uncertainty in any type of litigated situation. These are projections. So, I think we've all seen that it's very tough to project that far into the future. There's other factors that could delay projects or that can affect projects. My main thought process here was, how is the company going to meet the RPS standards in each of the years?
And do you have a position on exceeding the RPS standards as opposed to meeting the standards, given the cost of this project and the size of this project?
Well, I definitely respect the fact that it is a process. It's not needed in any one particular year. But I think in order to show reasonable and in order to make reasonable progress towards a goal, there has to be something in the plan that is going to get us there.
Let's change to a different subject, and I think I can close out Mr. Martinez. I'm going to try one more time to close Mr. Martinez's testimony and go back to your own. On page 11 of 33, you talk about the pricing of the lithium pricing adjustment to the battery storage component of the ESA portion. Do you know when that renegotiation or walkaway clause would be triggered in time, not in dollar amounts?
So I didn't read the entirety of the clause that outlined that parameter, but I've got to assume that any significant or material change in the lithium price would trigger that clause, which would then allow the company to, I think, ultimately renegotiate that price.
Do you know what, do you have an opinion as to whether EPE would need regulatory approvals if it renegotiates the price?
It makes sense that they would, yes.
It makes sense that they would, but do you know whether there's a rule or an order that would require them to do so?
Yeah, that's what I was just thinking about, was where the requirement would come from, and I can't place my finger on it at the moment. I'm just thinking of it through a normal contract negotiation process. If there's a material change in any price, I would presume that the company would come for approval to validate it.
Page of now, I think we're just about there. Page 13 of 33 of your testimony. A few questions on the selection process.
Okay, I believe I'm there.
Okay, the first full question and answer on that page, beginning on line 4, has to do with the EPE's decision to eliminate Hecate Energy from bidding in this case, right?
Right.
Do you know whether Next Era, the developer of the Buena Vista project, submitted a bid in this case? One or more bids?
I'm going to have to object to that question as to relevance.
Ms. Stevens?
Well, the relevance is, I would like to ask Mr. Tupler whether PE rejected or eliminated Next Era as a bidder, but I need to know whether Next Era was a bidder.
Do you know, Mr.?
I'm laying the foundation for the question.
Can I hear that again, please?
Do you know whether Next Era, which is developing Buena Vista, submitted one or more bids in response to the RFP that ended up with the selection of Carne?
I know it was a rather robust response from bidders, but I cannot validate that it was one particular company or another.
So does that mean you did not review the discovery responses that included the bids of, all the bids?
I probably reviewed it. I just didn't keep all of the bidder names in my mind.
Okay.
I think the record would speak for itself, though.
Okay. And also on page 13 of 33, you have a note 14 about the Plexos model.
I see it, yes.
Are you familiar with that model?
Only through this case and through the testimony provided.
Okay, so you've never run it yourself.
I have not.
Have you reviewed the outputs of that model as it was used in this case?
I can't recall seeing any specific outputs from the software, no.
And have you reviewed EPE's inputs, the assumptions and other inputs into the model for this case?
If I'm not mistaken, Mr. Oliver, I believe, stepped through the inputs that were utilized. Nothing stood out to me.
Okay, one last question. On page 15 of 33, lines 15 through 19, I think that you've basically just answered this question, but when you're talking about the your answer, how did the original shortlisted bidders respond to EPE's BAFO, or best final offer request?
Mm-hmm.
And then you testify that EPE received 13 revised BAFO proposals from 11 of the original shortlisted bidders due to previously mentioned industry-wide challenges in the market. Most of the revised BAFOs reflected an increase in price and a change in COD to a later date as a result. Is that based on your reading of EPE's testimony in Mr. Oliver's report, or is it based on an independent review of the original and the best and final offers?
I based my answer there on the testimony that was provided. There was no review of the actual bids received.
Thank you. That's all I have for you. It's good to see you again, Mr. Tepler.
Thank you.
Thank you, Ms. Stevens. Ms. Souls, do you have any questions for Mr. Tepler?
Yes, I have just a couple of questions. Hello, Mr. Tepler. I'm Mary Lee
Hello,
Souls,
Miss.
pro se party in this case.
Yes, ma'am. Good to see you.
Good to see you as well. Please go to page 6 of 33.
Is this in my testimony?
Your testimony, sir. Yes, please.
Okay, page 6 of 33. I'm there.
All right. At line 23, you're discussing the approvals EPE is requesting from the commission. Do you see that?
Yes, ma'am.
If the commission were to approve the Carne project, do you understand that to mean that the commission would be approving the Carne purchase power agreement and the Carne energy storage agreement?
Yes.
Would the commission also be approving the interconnection agreement?
It is my understanding that the PPA cost is to the interconnection point.
And therefore, what's your conclusion? Would the commission be approving the interconnection agreement that El Paso Electric is entering into?
I don't think I can answer to that. I'm not aware, I don't know the interconnection agreement terms, nor at this moment the requirements for the interconnection. I focused on the resource procurement and related, the resource procurement cost.
If the commission were to approve the Carnate project, would they be approving the costs associated with the interconnection?
It wasn't requested in the application, so my answer would be no.
So in your conclusion recommendation that the commission should approve the Carnate project, you see that as being related to the costs for the ESA and the PPA, but not the interconnection costs? Is that accurate?
Yes.
Well, would approval of the Carnate procurement mean that the commission also approves the associated cost recovery?
That sounds right, yes.
Very well. Would you please go to page 13 of 33 in your testimony?
Okay, I'm there.
You're faster than I am today. At line 1, you mentioned the calculation of the levelized cost of energy. Do you see that?
I do.
As an economist, have you conducted calculations of the levelized cost of energy?
I've not calculated them myself. However, I've tried to understand and analyze the variables that go into it.
So with your comment here that we just looked at, you include a footnote number 13. Do you see it?
I do.
And do I understand this says that the estimated interconnection costs were part of the calculation of the levelized cost of energy?
I believe that to be the case.
And yet you just told me that you didn't understand the interconnection costs to be part of the approvals that were being requested. Is that correct?
I believe as you asked the question, that's correct, yes.
Would you care to expand if you thought the question was misleading?
Well, I understand the rule equates the PPA price to the levelized cost of energy otherwise.
So in the levelized cost of energy calculations related to Carnate, do you understand that they included the proposed PPA price? Yes?
Let me understand that question again, please.
Is it your understanding that the proposed PPA, purchase power agreement price, was included in the levelized cost of energy?
I'm not necessarily, I believe the PPA is equitable or equal to the levelized cost of energy if there is a cost in the PPA.
What's your understanding of the cost that is represented by the PPA?
Well, it's the result of a strong RFP. So I would say it is the market price for the energy purchased through that contract.
And what was that price?
I don't have it right in front of me, but I believe it was somewhere in the $20 per kilowatt hour, if I'm not mistaken.
Would you like to
It's in
find that price? It seems important to me in terms of the levelized cost of energy.
Agreed. So I
What
know
is
it's in
that
my
price?
I know it's in my testimony somewhere. Let me scroll through it and see if I can find it. Okay, so I believe it to be $29.96 per megawatt hour. I feel better
You
about that
understand?
number.
It's your understanding that that was part of the calculation of the levelized cost of energy?
I'm not certain there was a levelized cost of energy calculated. My presumption here was that the $29.96 replaced the levelized cost of energy by rule.
Would you care to read your testimony here that refers to the levelized cost of energy starting on the previous page? Say at about line 19 on page 12 of 33.
Page 12, 33. Okay, I'm there. What am I reading?
You are in your testimony discussing how the levelized cost of energy was used.
Okay, so I'm on page 12 of 33. Help me find the line number I need to find.
Start on line 20, the sentence that begins after further qualitative.
I see it. Okay, so let me get some context here by reading the entirety of the answer. Okay, so it appears that in the bid evaluation process, the company did calculate a levelized cost of energy as part of their ranking.
Would they have included the $29 and was it 93 cents per megawatt hour specified in the PPA? That's your understanding?
Yes, ma'am.
Is it your understanding that they included the cost for the battery capacity that's specified in the energy storage agreement?
Yes, ma'am.
What is your understanding of the costs that they estimated for interconnection costs according to your footnote 13?
Let me read the footnote. I see. So it had to have been included in the levelized cost of energy amount.
And do you know what that value would have been?
I don't.
Do you know how they would have determined it?
I don't.
Very well. I have no more questions. Thank you.
Thank you, Ms. Souls. Mr. Downs, do you have any questions?
I have no questions, Madam Hearing Examiner. Thank you.
Doña Ana County, Mr. Herman?
No questions, Madam Examiner.
Thank you. Mr. Tepler? So, Mr. Tepler, generally staff supports approval of the EPE plan.
Yes, ma'am.
And you mentioned earlier that you weren't sure about whether or not Macho Springs could be utilized for satisfying EPE's obligations.
Well, in my original testimony, I believed it to be a reasonable substitute. However, since then, I believe that I've read or seen something to the effect that the Macho Springs reallocation may not be eligible. So I'm a bit unsure of what the specific rule would require. I just don't have that expertise on that particular element here.
But if Macho Springs were going to be utilized to satisfy EPE's requirements, they would need to request approval for that.
Yes, ma'am.
And they're not requesting approval in this case.
Exactly.
So your understanding is with this proposal, EPE should be able to satisfy their 2023 and 2024 obligations without having to backfill, so to speak, from 2025 or later years?
Well, I would say based on the plan and the projections and the forecasts, on paper, it looks good.
Okay. But you indicated that you are recommending, is it quarterly reporting, compliance reports? And I think that's on page 19 of your testimony.
Yes, ma'am, that sounds about right. Let me get there and I'll validate it. Okay, I'm almost there. Page 19, you said, Madam
Yes,
Hearing
of
Examiner?
page 19 of 33. You're making a recommendation that quarterly or compliance reporting be recommended to the commission.
Yes, ma'am.
Okay. And what would be the utility, in your opinion, of this type of compliance reporting?
Well, I think it serves two purposes. First and foremost, I think it will help staff to understand the confidence level of meeting the RPS hurdles each year, especially in a very difficult environment, I guess is what I would call it, with projects being delayed, rules changing, things that are going to affect the RPS budget is what I can call it. The second purpose is it'll maybe help the company get to where they need to be RPS wise.
Okay. And are you aware of any impediment to EPE having excess capacity?
An impediment to it?
Any legal or regulatory or other limitation that would, well, let me back up. I mean, my understanding is that the Carney project will result in 2025 in producing more solar energy than they're required to under the statute. So they're required to produce 40%, and they would in fact be required producing something like 48 or something percent in 2025 and something like 54% in 2026.
Yes, ma'am.
Is that okay? So is that in do you see that to be in any way inappropriate under any statutory or regulatory scheme? Any reason why EPE shouldn't produce more solar energy than they're required to under the statute?
I see. So it's my understanding that these RPS requirements are statutorily minimums. Thus, any additional procurement or generation, maybe even properly, is a plus. It gets us towards the RPS goal in the following year or the following hurdle, maybe a little quicker. And I don't see that as a bad thing.
All right. And then the cost that's going to be passed on to the consumer is addressed by Mr. Otara in his testimony.
Yes, ma'am.
And then with respect to the recs, on page 24 of your testimony, you're recommending approval of the plan under the prior Rule 572 interpretation on recs, but that future plans would have to comply with, well, whatever the new standard is as it's finally determined.
Yes, ma'am.
I don't have any questions for Mr. Tupler. Is there any redirect, Ms. Regensburg, based on any of the cross-examination of Mr. Tupler?
Yes, Madam Hearing Examiner, I have a couple of questions. So, Mr. Tupler, could you go to Commission Exhibit 3?
Okay, let me get there.
Responses to the bench request order. And are you there?
I'm a little, I have too many documents open again, but I will get there in a matter of clicks.
Okay.
Bear with me, I'm sorry. Okay, Commission Exhibit 3, I'm there.
Okay, and then go to page 3 of 6 for the Bates number.
I'm there.
And could you read footnote 1 at the bottom of that page?
Okay, is this just so that I'm...
Yeah, just go ahead and take a look at it. And you have, at the bottom, you have noted that there's an updated VM-3 table as Exhibit A, right?
Yes.
So if you go to page 5 of 6, you have Exhibit A
I see it.
in this table. Okay, and now I think it's important to go and show where we got this table. So in comparison, so let's go to Commission Exhibit 2. You might have to open that one up. That's Victor Martinez's response to the bench request order.
So I'm looking for Commission Exhibit 2.
Correct. It was admitted, I believe, on January 30th.
Commission Exhibit 2, I believe, is supplemental testimony of Victor Martinez.
That's right.
Okay, I'm there.
Okay, and then go to page, let's see. Sorry, I moved off of it. It would be the table VM1-S.
I see it.
So that is on page, Bates page 4 of 11.
Correct, yes.
Is this the same table as the table that you cited in your testimony?
Well, if this is the supplemental table, I haven't seen this one in this form before, but if I do a quick comparison, this would be what I would consider the updated table.
Okay. Thank you. And then just one last question. Are the calculations that are made for the reasonable cost threshold different than calculations that you would make for determining the levelized cost of energy?
Are they different, is your question?
Yes.
I would say they can be.
Okay. I don't have any other questions. Thank you.
All right, thank you very much, Mr. Tepler. I believe
Madam
you're,
Hearing Examiner?
oh
I-
yes, Ms.
To
Stevens, do you?
follow up on your questions?
Well, we
Follow
haven't
up?
had recross. Are you asking for recross, Ms. Stevens?
I'm asking for recross based on your questions about excess capacity. Yes.
I'll allow a couple of
Okay,
questions.
sure. That's all it's going to be. Thank you. Hello again, Mr. Tupler.
Yes, ma'am.
I'm not, oh, there you are. My screen's gone. Wait, so the hearing examiner asked you, are you aware of any limitations on EPE having excess capacity? And your answer was basically having more renewables is a plus. Do you have an understanding of what the cost responsibility for New Mexico customers will be if Carne is added to New Mexico costs that we discussed $20.5 million a year without the commission addressing what offsetting cost reductions will occur?
Ms. Stevens, I believe that's beyond the scope of what I asked Mr. Tupler. That appears to be going into the costs of the program, which are addressed by Mr. Otara, the next witness.
Madam Harris, I beg to differ on that. Mr. Otara only discusses the short-term costs in the RPS cost rider for 23. Now, he's not looking at this $20.5 million cost because it doesn't arise, actually it doesn't arise in full till 2026, just doesn't show up in the staff's testimony, either witnesses, is my understanding.
It's beyond the scope of what I asked Mr. Tepler, which was
Okay,
whether or
well,
not
I
there was
guess-
any legal, statutory, or regulatory restriction. That
Well,
would-
may I ask him one question about the Public Utility Act then?
Sure, yes, you may.
Mr. Tupler, are you aware that the public utility one of the stated initial policy of the Public Utility Act is to assure proper utility services without unnecessary duplication and economic waste? Is that a familiar phrase to you?
Yes, ma'am.
And do you believe that the Renewable Energy Act eliminated that objective and goal of the Public Utility Act?
Objection.
Stevens.
Calling for a legal conclusion.
Sustained. Thank you,
Well,
Ms.
yeah.
Stevens.
I will stop then, but he was asked a legal question. Thank you all very much. Right.
All right, I think,
you.
Mr. Tupler, this would conclude your testimony, so you're released as a witness, and I believe Mr. Otara is in the Zoom meeting. Thank you, Mr. Tupler.
Thank you.
Thank you. At this time, staff calls Badu Utara.
Okay, Ms. Gonzalez, can you swear in Mr. Otara?
Raise your right hand, please. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Good afternoon, Mr. Otara.
Good afternoon, Mr. Bowman.
By whom are you employed and in what capacity?
First, my name is Watara, like OUA. So,
Okay.
yeah.
My apologies.
So I'm an economist and I work for the Public Regulation Commission at the Utility Division.
As part of your duties in that position, did you review the RPS plan submitted by El Paso Electric in this case, along with the testimony filed?
Yes, I did.
And based upon that review, did you prepare or participate in preparing testimony regarding that RPS plan?
Yes.
You should have before you a document that's been marked as Staff's Exhibit 2. Do you have that?
Yes, I do.
Was Staff Exhibit 2 prepared by you or under your supervision?
It was prepared by me. Yes.
Do you have any changes or corrections to the testimony in Staff Exhibit 2?
Following the bench request, Epe'S response to the commission's bench request, some of my values will have to be changed but the final recommendation in this testimony will still be the same.
And so when you refer to the final values of the values that are in your testimony, can you tell us where those are?
The final values in in Staff Exhibit page 7, the bill, the questions that say what is the bill impact on residential customers of the proposed 2023 RPS Ghost Rider? So the two values will have to be changed. The customer's average bill of $1.44 in the summer and $1.02 in the winter. Those will have to change, and also the reconciliation value will also have to change.
Okay, so, and just to make sure we get this clarified and you have it straight on the record, you said that's on page 7?
Yes, on page 7.
Okay, I'm looking at, and I want to make sure we got the right page 7 because we have that and we have the, I guess, the bait stamps number. So is that page 7 of 15 or is that page 7 that's marked in the lower right-hand corner?
It's page 7 in the lower right-hand corner.
Okay, and so on the lower left-hand corner, we have the bait stamp number and that says page 9 of 15. Is that
Yes,
correct?
That's correct.
Okay, and then can you, what line were these changes on?
Okay, the first will be like on line 15.
Okay.
Line 15, another change on line 7.
Okay.
Yeah, and another one on line 4.
Okay, so now, and these changes are based on the information that was submitted by El Paso in response to the bench request after you submitted your testimony, is that correct?
Yes, that's correct.
Okay, so Madam Hearing Examiner, I guess I'd propose that staff would submit a corrected version to correct these numbers on here with your approval.
Yes, I was going to actually make a bench request to that effect, that Mr. Watara's testimony be corrected based on the supplemental testimony provided in response to the bench request.
Thank you. And Mr. Watara, I think you indicated that while these numbers would change, your recommendation would not change. Is that what you said?
Yes.
Okay. If I ask you today the same questions as are put forth in Staff Exhibit 2, would your answers be the same as you have just corrected them?
Yes.
Okay, and are those answers true and correct to the best of your knowledge?
Yes.
And do you adopt Staff Exhibit 2 as your sworn testimony in this matter?
Yes, I do.
Thank you. Madam Hearing Examiner, at this time I move admission of Staff Exhibit 2.
Any objection? Hearing none. Exhibit 2 is admitted, subject to being updated through the bench request.
Understood. Madam Hearing Examiner, we also have a proposed Staff Exhibit 3, which I think we've talked about to some degree in the past. It's the it's the document that includes, I guess, the advice notice and fifth revised rate number 38. And while it's not a document that Mr. Watara could authenticate, I don't know how you would, I think you indicated that you wanted to make this a part of the record rather than take administrative notice.
Correct. Is there any objection to staff exhibit, well, which really isn't part of Mr. Watara's testimony, I guess, but does anyone have any objection to staff exhibit 3, which for which we could take administrative notice, but just to clarify, we would have it in the record.
Madam,
Hearing no-
oh,
Yes, Ms. Olson, go ahead.
I don't have an objection, but I don't have the document in front of me, and I'm just wondering, could you tell me the date of the filing, Mr. Borman, so I'm clear which advice notice this one is?
Opening up, it looks like it was filed on January 27th, 2022. That's at least the email filing, and yes, that appears to be the date.
So this is the advice notice that went into effect February 1st with the SIRLIF.
I think I'm looking on here. It was filed January 27th. I can't tell you exactly when it went into effect. I'm not finding that on here immediately. In fact, yeah, it went into effect February 1st, 2022.
Okay, yeah, I have no objection. Thanks for that clarification.
Staff exhibit 3 may be admitted.
Thank you. With that, I have no further questions. Thank you, Mr. Watara.
Thank you.
El Paso Electric, do you have any cross-examination for Mr. Watara?
Good afternoon, Mr. Watara. Very nice to meet you. I do not have any cross-examination for you this afternoon.
Good afternoon. Thanks.
Mr. Gedko for the Attorney General.
No, we do not have any questions for Mr. Watara. Thank you.
City of Las Cruces, Ms. Stevens.
I have a couple. Thank you. Good afternoon, Mr. Watara.
Good afternoon.
Since you're a PhD candidate, I had to ask you this one. Can you pull up EPE exhibit C8, I believe it is? Hold on a second. Here I have my notes. EPE exhibit 8, Renee Gonzalez's rebuttal testimony.
Okay.
And now let me make sure I've got it too, if you give me a second. And I'd like you to go to page 12 of 30 on this testimony, on the Bates stamping numbers at the bottom.
Okay, I'm on that page.
And I'm on the lines 1 to 2 at the top. And
Yes.
Mr. Gonzalez referred to the associative property in mathematics. And I wanted you to, if you could explain to me what relevance that has to your own and staff's accepting EPE's reconciliation methodology in this case.
Okay, thank you. The associative property, like I cannot give you a mathematical definition.
I'm sorry, please repeat that. I'm not hearing you.
Yeah. Do you hear me? No?
Now I do.
That's better.
I was saying that the associative property in mathematics, like I cannot give you a definition at the moment, like a clear definition at the moment, but I believe that this was used to basically say why it wasn't appropriate to say that calculating the reconciliation value of 2021, like it's not better to do it cumulatively versus year by year, like a year by year analysis. Like, I mean, that's what I can say about the association.
Did you review Mr. Provencio's testimony for the city and Ms. Solz's testimony on behalf of herself?
Yes, I did.
And are you familiar with the idea that their testimony is recommending that in order to do the reconciliation, one totals up the total actual costs and the total actual revenues and comes out, the reconciliation is the difference between the cumulative total actual costs, not the cumulative, but the total actual costs over time and the total actual revenues. Are you taking issue with that principle?
I believe that was the argument.
That was I'm sorry, I didn't understand that word.
I believe that was the argument, Mr. Sue's argument. Yeah.
Yes. And do you disagree with them that it's appropriate to total up actual costs and actual revenues to come up with the reconciliation of the difference between actual costs and actual revenues?
Yeah. I cannot say that I disagree with that approach. The problem is it's just not consistent with what was practiced before, like in this case.
Like in this case, would you, let's see, I didn't mean to take you here, so I'm sorry. If you would open up CLC exhibit, CLC exhibit 3, Mr. Provencio's testimony.
CLC exhibit 3. I have
good, great. Could you turn to page 64 of 175? It's Mr. Provencio's exhibit JFP1.
Which exhibit again, please?
It's exhibit JFP1. The way to find it is by the Bates stamping in the lower left-hand corner, which is page 64 out of 175.
Which document is this testimony in?
CLC exhibit 3, Mr. Provencio's direct testimony.
Okay. I'm on the Dropbox page at the moment. I cannot find CLC exhibit 3.
I can send it to the witness.
Okay. Would you do that? There's so many places.
Yeah.
Thank you, Brett.
See. Try to get this. It'll take me a moment. Okay, just sent it to Bahadur.
Have you got the exhibit now? Page 64 of 170.
Have you sent it, Mr. Bowman?
I have sent it to you.
Yes, I have the exhibit.
And now if you would go to page 64 of 175 on the Bates stamping or the little toolbar at the top.
I'm sorry, what page, Ms. Stevens?
64 out of 175.
Thank you.
Uh, 64 out of 175.
Right.
Yes.
Okay. I know that you're a new addition to staff, Mr. Botaris. I'm wondering, what do you know about how the previous reconciliations were actually accomplished? Do you know what happened in case number 19-00099-UT?
Okay. To answer to that question, actually, my analysis of this case, especially like of the reconciliation process, was based on the reconciliation filing provision.
I'm sorry, I'm not understanding you. I'm answering that question. Actually, my analysis of this case, especially in the reconciliation process, was based on.
Okay, the reconciliation process in this case, my analysis of the reconciliation process in this case was based on the reconciliation filing provision of Epe'S existing permission approved rate number 38, RPS cost rider in case number 18.00109.UT, effective February 1st, 2022. So basically, a reconciliation filing provision was approved, which says that the rider shall be adjusted to reconcile a prior plan year's RPS cost rider.
I'm sorry you're reading that. I need it way slower, please.
Okay. The provision reads as follows. The rider shall be adjusted to reconcile a prior plan year's RPS cost rider revenues with actual RPS costs. Any over recovery of the previously approved RPS costs will represent a credit to a reduction of the approved rider in a subsequent plan year, and any under recovery of previously approved renewable energy costs will represent a charge in addition to the approved rider in a subsequent plan year. So based on this, a cumulative approach in calculating the reconciliation, was not like in this provision. So I cannot say that I'm against doing it in that approach, like cumulatively, but it's just not consistent with this provision.
Does that provision specifically say that one should look to 2 years prior?
But it doesn't say 2 years prior. It says a prior planned year cost. So
Okay. Is it your belief that if one year does not fully, if one reconciliation does not fully reconcile past costs, those costs should just be written off one way or the other, and you just leapfrog over to another 1 year period?
can you please ask that question again?
Okay. Is it your opinion that under the tariff language and under your recommendation that that there is a one-time opportunity to reconcile a single year's costs and revenues? Or do you think that at the end of the day, the objective of the rate rider is to balance out cumulative costs and revenues?
Yeah, I believe that a single year's approach should actually be enough to do a reconciliation. Do you hear what I'm saying? Can you hear me?
I can. I don't know about the court reporter. So if the reconciliation factor that's built into a rider in a particular year does not nail it, does not exactly accomplish what was intended, are you saying that differential should just be forgotten, or that it should be adjusted going forward so that in the long run you have equilibrium?
That's not my my understanding of this provision. Based on this provision, like if the reconciliation is done correctly for this year, so we either have like an over collection or an under collection. So in the next year, we'll have to like credit the, okay, like in the next year. So like if we have an over recovery of the previously approved cost, the next year, this will represent a credit and a reduction in the rider rate, and vice versa, like if we have an under recovery. So basically, if this is done correctly, like every year, I believe that we should not have like a problem, or we don't actually need to go back 2 years before or 3 years before to try to like even out, because it's going to be taken care of. That's my belief.
Do you understand that that when you do the reconciliation, as you've done, as Mr. Provencio did, as Mr. Gonzalez did, that you're doing factoring in a projected amount based on projected number of kilowatt hours? So it would be basically miraculous if you actually got, say, looking at the bottom line in JFP 1 to actually actually hit $829,479.09 based on a projected rider component would be next to impossible?
Yeah, I believe that's why we have the reconciliation like in the first place, because we're doing the calculation based like on projected values, but not on actual values. So like at the end of the year, we look at the projected values versus the actual values and do basically a comparison. And then we have a reconciliation, which will end up in either an over recovery or under recovery. So like if we're doing it based on the actual values, I don't think we'll actually need to do a reconciliations, but it's because we're doing it on the projected values, because we don't know for sure what's going to be the revenues of next year. Like it's a projected value, it's not actual values. So, I mean, that's my answer to that.
Well, let me follow up on that.
Yeah.
But you come in a year later, 2 years later, and try to project the makeup amount, the reconciliation amount, don't you run into the same issue with it being the dollar amount, the target amount is known, but the ability to get there based on a tiny little, fractions of a penny times projected kilowatt hours, you're still not going to be 100% accurate. That's my question to you. I mean, do you understand that first of all, do you understand that you won't be 100% accurate?
Yes, like I do understand that, it's not going to be 100% accurate. But I think that's why we do the reconciliation, because it's not going to be 100% accurate.
And
I
so
don't-
suggesting that we reconcile over and over and over and over again till we get to matching the costs and the revenues over time? Or are you recommending that there's an endpoint to the reconciliation process?
Could you ask that question again?
Okay, yeah, so is it your recommendation that, given that you can't ever project perfectly, that you should go on reconciling maybe smaller and smaller differentials in future years in order to get your RPS cost rider revenues exactly matched up to your RPS procurement costs? Or would you stop it at some point because you're trying to do a year-to-year fix?
I believe that because we're doing like a yearly,
I'm sorry, please repeat that. I believe that.
yeah, I believe that because we're doing like a year by year reconciliation, so like if the project end up, I would say like if the project end, let's say 10 years from now, so at the end of the project, we will still need to do a reconciliation. And so like if all the reconciliation were basically done like they're supposed to be, like properly, they're done properly, at the end of the project, we still have like either an over collection and under collection, and that value will go back to the customer. So like if there is an over collection, the extra value will still go back to the customer. So I actually don't see, like, I don't understand why doing it cumulatively will be better than doing it year by year. So that's my position on this question.
And I'm not sure I quite understood. I think there are two components of what you just said, that you would look at it on a kind of a project lifetime basis is one component. And the other was, were you saying that at the end of the lifetime, you would not reconcile once again, but would just, you know, take your chances, whether ratepayers or the utility come out ahead? Is that what you just told me?
Objection, I think that misstates the witness's testimony.
Okay, no, I'm really trying to clarify, because I'm sorry, I really have a lot of background noise here. So are you trying to, at the end of 20 years, would you reconcile yet again to, again, match the total numbers over time precisely? Or are you saying that at some point you let it go?
Okay, like I'm not sure like if I'm in a position to say exactly what's going to happen at the end of the lifetime like of the project, but my belief is that like if we stick to this provision, doing the reconciliation like on a yearly basis, I believe that there should be no problem. I mean, that's my belief. Like, I don't know what you're really trying to understand here. Maybe like I don't follow you properly, maybe. So if you could maybe explain like, or ask the question again.
I think we'll just leave it there. I'll ask you one question to follow up with what the hearing examiner asked of Mr. Tupler. None of your testimony addresses the additional costs for future rate riders that will arise as a result of adding the Carne project. Does it? Did I miss something?
Mine doesn't address it.
I'm sorry, please repeat.
My testimony doesn't address that.
Okay, thank you very much, Mr. Otara. Looking forward to meeting you again. Good luck.
Thank you.
Ms. Souls, do you have any questions for Mr. Watara?
No, ma'am, I have no questions for him.
Thank you. Mr. Downs,
I have no questions, Madam Hearing Examiner.
Mr. Herman for Doña Ana County.
No questions.
Thank you. Mr. Watara, approximately how long would it take for you to revise your testimony, which I assume would be to incorporate the information contained in the February 7th response to bench request that was filed by EPE?
I think it can be done in less than 2 weeks. I would say a week, but it can definitely be done in less than 2 weeks.
Do we want to say like early next week? Can we promise that?
Yes.
Okay.
So I think, let's see, we'd be looking at next Thursday, the 23rd, or the 22nd, 20, the 22nd or 23rd, Mr. Watara?
The 22nd should work for me. Yes.
Okay. Okay, and that'll be filed as a response to bench request.
Is it, yes, is there a particular number bench request that this is, or just say hearing bench request of February, what is today, 16th?
This would be the second bench request to staff.
Okay.
The first one was to Mr. Tupler in response to Commissioner Ellison's bench request. So this would be the second bench request to staff.
Thank you.
Madam Hearing,
Yes.
Anastasia Stevens, I'm not quite sure exactly what these calculations are going to be, but I'm slightly concerned that Mr. Provencio did calculate a rate himself, and I'm not sure whether we're going to end up with staff and the company way out ahead. And I honestly haven't thought about it enough to know. So I guess I would ask you for an opportunity to file, if necessary, a request, a motion or a rebuttal piece. I really haven't thought it through as to what what the goal here is in terms of actually calculating a specific number or.
Well, why don't we complete if we can complete Mr. Watara's testimony. I understand the concern from the revisions that were made as a result of the bench requests that were filed on February 7th. And so, we may have some discussion about that, but I think actually the question I had for Mr. Watara also related to the net increase in the typical residential customer's average bill, which I believe we've already discussed. So I don't think I have any other questions for Mr. Watara. Any other
I have
follow-up?
Direct.
Thank you. All right, I think that will conclude your testimony, Mr. Watara.
Thank
So
you.
you can be released today. So I had a couple of, I guess, follow-up questions. I think, we've addressed all the exhibits, I believe. Commission Exhibit 4 I saw was uploaded. Does anyone have any question about admitting Commission Exhibit 4, which has now been uploaded to the Dropbox? No. Okay, then Commission Exhibit 4 will be admitted. And just so that we have a good set of exhibits from today for our court reporter, I will send out a new Dropbox link tomorrow to a new folder. And so if everyone who had exhibits admitted today can please upload them properly labeled to that Dropbox. I'll probably set it up and send it out tonight, but to have those uploaded for tomorrow, by the end of the day tomorrow.
Madam Hearing Examiner, I'm sorry for being so difficult. I'm just concerned, in addition to the ones that were uploaded today, should Miss LaRock's testimony, because she had that conditional admission, should it be admitted, should it be uploaded today or tomorrow, or and I know you're juggling, you're trying to keep all this stuff straight as well, but
Right.
I'll admit to being confused.
Let's see. So today for the city of Las Cruces, we had exhibits 1, 4, 9, 10, 11, 12, and 13. The only issue was whether or not it was the correct. I don't think it was conditionally admitted. There was some confusion about which version we were discussing, and I was going to delete from the Dropbox the old version. But now that I'm saying we're going to do a new Dropbox folder for all the exhibits admitted today, you should upload the exhibit that was admitted, which was the February 1st, 23 version of Ms. LaRock's testimony.
Thank you very much for that clarification.
Great. Hopefully we're going to come up with a better process in the future. I don't know.
Is this an ongoing commission-wide hearing examiner challenge, or are you taking this task upon yourself solo?
No, I think we are all, use of the Dropbox has not really been perfected, I guess I would say. But we're working on it. I also want to, and everyone else is clear on what exhibits were admitted today, and that they should upload to the Dropbox, the new Dropbox folder, which the court reporter will use for purposes of the final transcript. So Ms. Souls, you had exhibits 1, 2, and 3 that were.
I believe I had
5 and
exhibits.
6, 1 through 6.
No, 5 was admitted previously. Today
4.
was 1, 2, 3, 4, and 6.
Yes. Okay. And EPE, I think the only exhibit you had today was what we were going to denominate as exhibit 10.
I think that's right. Do you want me to also re-upload the commission exhibit 4?
Yeah, that would be great. Thank you. Okay. So hopefully that takes care of the exhibits. I had a question with respect to the response to the bench request. Pull it back up. I had it. I was just looking at it. Okay. Okay. So this was filed to the e-docket on February 7th. And this is EPE's response to the commission bench requests issued during the public hearing. And so this provided some revisions to the calculations that were used by EPE. So it was a corrected 2021 reconciliation, a revised 2023 RPS cost writer calculation, a revised residential bill impact, which updated exhibits. And I can share this if that would be helpful while we're discussing it. Does everyone have this in front of them?
I don't have it in front of me, but
No, ma'am. Were you going to share it?
Yeah, I can. Sorry, I have so many windows open. It's a little awkward here.
I'm using 3 screens right now, so.
I wish I had. I'm at home. I only have 2. Okay. So here it is, the document that I'm referencing this just actually pulled up right out of the e-docket filed on February 7th. So I was primarily discussing the response here to bench request 2, reflecting the adjustments that EPE made to the proposed 6th revised rate number 38 RPS cost rater. So these are the changes that Mr. Muatara would be evaluating in his revised testimony.
These are the changes that, as I understand it, result in changes to a handful of numbers in his testimony.
Correct. Right. So a question that I have for EPE, and I don't necessarily expect an immediate answer, is whether any of these changes are of a magnitude that would suggest that the notice needs to be republished.
My understanding, Madam Hearing Examiner, is that the overall impact would be a lower rate. And because it's a lower rate, we don't have to do revised notice.
I think that's right. From my understanding of the impact on Bomater's numbers, that seems to be correct.
Great. An answer hopefully that everyone would be happy to hear. And so with respect to discussion of these change numbers, given, for example, Ms. Soule's reliance on the original set of numbers, you are certainly free to utilize these numbers to demonstrate however this might affect your testimony. Does that make sense, Ms. Soules?
Let me ask for clarification if I may.
Sure, go ahead.
Are you telling me I may file supplemental testimony using these numbers, or are you telling me I may use these numbers in briefing?
I think that you can use them in briefing, if that would be, I think it would be preferable to use them in briefing. So that, for example, if you relied on number X in your testimony, in your brief, you can say, however, you know, the supplemental, the response to bench request that was filed by EPE utilizes this number Y. This would have this impact on my testimony, if any, and my recommendation.
Very well. Thank you for that clarification.
Okay. Anyone else have any questions about that? How that might, and I think similarly, like if this has an impact on, you know, any witness's testimony, that can certainly be addressed in the course of the briefing. So So with respect to the briefing, we have our new dates, and I'll send those out in an order, which I can also incorporate the bench request in that as well, if you think, Mr. Borman, if that would be preferable.
Whatever works best for you, Madam Hearing Examiner. I mean, if you wish to put it in the same order, that's fine.
So, you know, the goal is just to have the best record we can. And it's a little bit challenging when we had this change, but since, you know, I think it's going to result in a lower rate, hopefully, it's a positive change overall. And I, again, appreciate the parties creating a joint proposed recommended decision on issues that are agreed, and for issues that are disputed, you know, I would again just ask the parties to keep in mind the organization of the rule in presenting their arguments so that they track fairly readily from brief to brief. And I think that that's everything I had. I would just like to thank everyone for their efforts in the success of completing our hearing.
Thank you very much.
Thank you, Madam Hearing Examiner, very much.
Thank you.
Thank you. All right, well, we are
Let's
going
go
off the
home.
record now in this matter, and I will look forward to seeing all of you in a couple of weeks.
Maybe not all.
Do it all over again, right?
Exactly. I think we will be.
Thank you.
All right, and everyone enjoy the rest of your day.
Good night.
Thank you.
Thank
You
you.
too.
Thank you.